Good morning. My name is Kenya McDuffie, Councilmember for Ward 5 and Chair of the Council's Committee on the Judiciary. Today is Wednesday, April 22nd, 2015. We are in 123 of the historic John A. Wilson Building. The time is now 10:11 a.m., and I'm calling to order this public roundtable of the committee. Today, the committee will discuss proposals relating to the powers of the Office of the Attorney General, or the OAG, and the Mayor's Office of Legal Counsel, which is commonly referred to as the MOLC. Still trying to get used to that, but it's called the MOLC. On March 16, 2015, the Attorney General introduced Bill 21-0139, the Attorney General Independence and Authority Implementation Amendment Act of 2015. The stated purpose of the bill is to outline the powers of the Attorney General by making OAG an independent body equal with the Council and the Mayor, giving the OAG the power to provide legal advice to all parts of the district government and to review and certify legislation, rulemakings, and certain transactions, clarifying that OAG has settlement authority for matters in litigation, with settlements in excess of $1.5 million, subject to the consent of the mayor, giving OAG independent personnel and procurement authority, expanding OAG's subpoena authority, and allowing OAG to bargain collectively independent of the executive. On April 14, 2015, Bill 21-158, the Fiscal Year 2016 Budget Support Act of 2015, was referred to the Committee of the Whole. Notably, Title I, Subtitle E of the bill was referred to the Committee on the Judiciary. This subtitle offers competing proposals to aspects of Bill 21-139 by proposing that the MOLC provide legal sufficiency reviews of legislation, regulations, and contracts, and that the relationship between the mayor and the Attorney General shall be as client to attorney. The scope of today's roundtable is where these two proposals intersect, namely, on the power to provide legal sufficiency and the legal relationship between the mayor and the OAG. This is not a hearing on the Attorney General's bill, although we will be discussing aspects of the legislation. I convened this public roundtable for two important reasons. Number one, to allow the public an additional opportunity outside of the Council's regular budget process to weigh in on these important matters. And number two, to set a more collegial tone as we explore as a district what it means to have an elected instead of an appointed Attorney General. The proposals offered by the Attorney General and the Mayor implicate fundamental policy decisions about the core functions of the district government, and it is my view that the changes to existing laws should not be taken lightly. At the same time, the voters of the District of Columbia made the decision to elect an Attorney General, and we as a city need to move forward and get to work. As this committee wrote in its report accompanying the 2013 law creating the MOLC, the suggestion that conflict will be devastating to the operation of government is overly cynical. As with conflicts that arise between different elected officials and different branches of government, there is a need for the government as a whole to continue to work together to move the district forward. And with that, I'll proceed with our public witnesses. Individuals testifying on their own behalf will have 3 minutes to do so. Those representing organizations will have 5 minutes, and I'd like to ask that witnesses be mindful of the clock and considerate of others who want to testify today. After public witnesses testify, I'll call our government witnesses from the executive, followed by government witnesses for the Office of the Attorney General. On the first panel, we have Fred Cook, Laura Hankins, who's Special Counsel, Public Defender Service of the District of Columbia, and Monica Hopkins Maxwell, who's Executive Director of the ACLU of the nation's capital. Forget about those?
Say again?
How's everybody doing this morning?
Yeah, good.
Fine.
Thank you.
Thank you each for being here. And we're going to start from my left and your right with Mr. Cook.
Thank you, Chairman McDuffie. As you indicated, my name is Fred Cook, and I had the great privilege to, at one point in my legal career, to serve as the Corporation Counsel of the District of Columbia, to be the Chief Legal Officer of the district. This discussion is one that is very important to me, having sat in the chair that's very similar to the current Attorney General, but also because I live here and care about how the city can best function. And I believe that the proposals that would effectively transfer certain powers from the Office of the Attorney General to the MOLC or similar agency are ill-considered and are probably inconsistent, certainly inconsistent in my view with the charter. And the legislation effectively amends the charter without following the process in the charter for charter amendment. In 2010, we collectively here amended the charter of the District of Columbia to provide for, among other things, an elected Attorney General. Nowhere in that charter amendment did the charter amendment change any of the powers of the Attorney General or transfer any of the powers of the Attorney General to any other agency or entity of government. It was a whole transfer of responsibility from an appointed position to an elected position. In 2013, legislation was introduced that effectively changed the reporting and the supervisory responsibility for a group of attorneys who worked in the various agencies of government from the Office of the Attorney General, where those people had been Assistant Attorney Generals, to the Executive Office, to the Mayor, for the Mayor to be their reporting authority in an ultimate sort of reporting sense. Those people were not empowered in that legislation to take on any of the responsibilities of the Attorney General. In fact, those people had formerly been Assistant Attorney Generals, and their new titles was a different title. They were no longer Assistant Attorney Generals because they were not discharging the law business of the District of Columbia. They were carrying out agency functions. And to some degree it made sense, and I did have an opportunity to testify about that legislation as well. The law business of the district in the charter is very clearly the responsibility of the Attorney General. Rendering legal sufficiency reviews, giving legal opinions about various legal matters, whatever they may be, however large or small they may be, is the responsibility under the charter of the Attorney General. The municipal corporation known as the District of Columbia has a chief executive called the mayor. The charter also establishes that the municipal corporation has a lawyer responsible for its law business called the Attorney General now, at one point the Corporation Counsel. This legislation mechanism is effectively changing that charter status, that charter creation, and you can't do it that way. So my view is that you've got a legal hurdle that I think is relatively clear and not surmountable, but you've also got a practical problem. If in fact the Attorney General is responsible for all the law business of the district, and you have these other lawyers who may say something legal, may render a legal opinion about something that is not ultimate because the Attorney General can countermand them, why am I, in my current life in the business world, why am I going to take an opinion from someone from the MOLC if I know that there's another lawyer in the government who can countermand that? The simple answer is I want to talk to the people who can make the decision. I want the guy or lady in the room who can make the decision. I don't want somebody who has to go ask somebody else. So I think it creates a practical problem in terms of getting transactions done. And this has got nothing to do with ability. This has got nothing to do with personalities from my perspective. Clearly, there is no magic about knowing the law. People in the MOLC can know the law. People in the MOLC have the ability to analyze and come to wonderful and probably correct legal conclusions. They just don't have the legal capacity to issue a legal conclusion or decision that has the legal force and effect as the Attorney General does. So this is not about your guys are better than my guys. This is about structurally who has the power to do this, who has the legal authority under our charter apparatus to issue legal opinions and to conduct the law business of the government of the District of Columbia.
Thank you for your testimony, Mr. Cook. Next, we're going to hear from Ms. Hankins.
Thank you. This is, I don't wait for a green light. Don't start my clock yet. This is on. Okay.
It's on. It's on.
Thank you. Okay. Thank you for the opportunity to comment today at this public roundtable on the proposals relating to the powers of the OAG and the MOLC. I am Laura Hankins, Special Counsel to the Director of the Public Defender Service. My comments today will focus on the subpoena authority requested by the Office of the Attorney General in Bill 21-139, specifically at Section 110 of the bill. Section 110 of Bill 21-139 would amend the DC Code to grant the Attorney General or his or her designee the authority to issue subpoenas requiring the attendance and testimony under oath of witnesses and the production of any evidence that is relevant or material relating to criminal offenses or any criminal, civil, or other matter being investigated by the Attorney General. PDS is very pleased to note that the Attorney General is specifically not requesting authority to issue subpoenas relating to the investigation of acts pertaining to a person suspected of being a delinquent child. We commend Attorney General Racine for taking this position. We believe it reflects his commitment to unlocking fairness for everyone in our city and to making our juvenile justice system one that promotes justice for and rehabilitation of juveniles and is not just a junior version of the punitive adult criminal justice system. However, PDS still opposes Section 110 of Bill 21-139 insofar as it would grant the Attorney General the authority to subpoena witnesses in any criminal matter. PDS firmly believes that the Attorney General should not have, in fact, does not need more subpoena power in criminal cases than he already has pursuant to DC Code Section 1301.89A. Currently, AUSAs, AAGs, and criminal defense attorneys all have the exact same subpoena power. The only power, subpoena power that we have is pursuant to Rule 17, both of the criminal rules and the rules governing juvenile proceedings in Superior Court. The prosecutors don't have greater power than defense attorneys, and AUSAs, the assistants in the U.S. Attorney's Office, don't have greater power than AAGs. We all have the same subpoenas. We all fill out the same forms that we get from the court because they're court subpoenas, because it's the court's power to compel witnesses to appear. No prosecutor and no defense attorney can require a witness to appear in his or her office for an interview or to make an oath under statement. We can only subpoena witnesses and documents to court. Section 110 would give AAGs power to compel witnesses to appear in their offices to provide testimony and produce documents in criminal cases. There is some confusion in the district because the U.S. Attorney's Office directs the grand jury and generally decides who or what will be subpoenaed to the grand jury, and the grand jury meets in the building of the U.S. Attorney's Office. Despite where in the district the grand jury convenes for DC Code offenses, the grand jury is actually supervised by DC Superior Court. Pursuant to the Fifth Amendment, no person can be held to answer for a capital or otherwise infamous crime except on an indictment by a grand jury. In practice, this means that a person can only be charged with a felony if a grand jury indicts the person on that charge. While the federal prosecutor directs the grand jury and may even issue a subpoena without the knowledge of the grand jury, his authority to do so is grounded in the grand jury investigation, not the prosecutor's own inquiry. In contrast, misdemeanors can be charged without action by the grand jury. Solely as an exercise of their discretion, prosecutors can charge a defendant with a misdemeanor by filing an information in court. The OAG does not direct a grand jury because it doesn't have the authority to prosecute felony charges. The only penal statutes the OAG has the authority to prosecute are those that are in the nature of police or municipal regulations where the maximum punishment is a fine only or imprisonment not exceeding 1 year, or specifically the minor crimes of disorderly conduct and lewd, indecent, or obscene acts. The U.S. Attorney's Office prosecutes misdemeanors that are, by our home rule structure, necessarily more serious than the OAG has the authority to prosecute. If the U.S. Attorney's Office can successfully investigate and prosecute these more serious misdemeanors without the authority to subpoena witnesses to their offices, indeed with no more subpoena authority than the OAG and the defense bar currently have, then the OAG should be able to continue to bring, as successfully as they have been, their less serious misdemeanor prosecutions. PDS takes no position on the proposal in Section 110 that would grant the Attorney General authority to subpoena witnesses and compel their testimony and compel production of evidence relating to any civil matter. And we again gratefully acknowledge that the Attorney General has recognized the inappropriateness of subpoena power in delinquency matters and is no longer seeking such authority. We urge this committee, however, to reject the Attorney General's proposal to expand his authority to issue subpoenas in criminal matters. With respect to the seemingly competing visions of the role of the Attorney General put forth by the Attorney General in Bill 21-139 and the Mayor in the Budget Support Act, PDS notes that a number of our clients are in the custody of and receive services from the district. Our clients are public school students. Our young people are entitled to special education services. They're juveniles in the physical and sometimes legal custody of DYRS. They're in shelter houses and group homes and at New Beginnings. They're patients at St. Elizabeth's. They're consumers of mental health services through the Department of Behavioral Health. They're detained and serving sentences at the jail and in the custody of the Department of Corrections. They're arrested by MPD. They have their evidence tested by the Forensic Sciences Department. We very strongly believe that district agencies would benefit from independent legal advice. We also believe that we have a strong interest in laws that are passed in the district, and we strongly believe that the council benefits from more perspectives on the legal sufficiency of bills, not fewer. And to the extent that the Budget Support Act and the declaring the Attorney General as the attorney, for the district government as a client, and restricting the Attorney General to providing legal sufficiency reviews and legislation only at the request of the mayor, to the extent that that restricts this council's ability to get competent legal advice, PDS would urge this committee and this council not to support those provisions. Thank you very much.
Thank you for your testimony, Ms. Hankins. Ms. Hopkins-Maclellan?
Thank you. Thank you for the opportunity to comment today on the Attorney General Independence and Authority Implementation Amendment. My name is Monica Hopkins-Maxwell, and I am the Executive Director of the American Civil Liberties Union of the nation's capital. I'm here today on behalf of our more than 4,200 voting members across all 8 wards of the District of Columbia. The ACLU of the nation's capital commends Attorney General Racine for proposing this important piece of legislation designed to fully implement the will of the voters and create for the first time an elected independent Attorney General for DC. We do urge the council to consider some provisions in the proposal, specifically with regard to subpoena power. The ACLU does believe that district residents must have confidence that the district's lawyers conduct their legal business without fear or favor, respecting the law and not pursuing the political agenda of anyone in either the executive or legislative branch of government. As we continue to transition to the significant change of an independent elected Attorney General, we must ensure that the necessary tools are in place so that he may effectively fulfill the duties as the district's chief legal officer. Legislative changes are required to allow the office of the Attorney General to properly function independently, co-equal with the mayor and the council. The legislation before us would clarify the powers of the Attorney General, including the Attorney General's exclusive power to determine the law of the District of Columbia and issue formal opinions on all government entities. The Attorney General's power and duty to provide legal advice to all parts of district government and to review and if appropriate, certify legislation, rulemakings, and significant transactions. The Attorney General's authority to control litigation, among a host of other things. Furthermore, the legislation would allow the Attorney General to submit a budget for the OAG and the mayor for inclusion in the district's overall budget. It would provide the Attorney General with independent personnel and procurement authority. It would also continue the Attorney General's role of approving the hiring of outside counsel. As there are many complex components of this legislation, I'll address a selection here. Under Mayor Bowser's 2016 BSA, the MOLC is given the responsibility to provide legal sufficiency reviews of legislation, regulations, and contracts, a function currently handled by OAG attorneys. The proposal further states that the Attorney General may also provide such reviews at the request of the mayor. The ACLU believes this BSA provision is problematic. Our independent Attorney General should have the exclusive power to determine the controlling law of the district and to issue formal legal opinions, the power and duty to provide formal and informal legal advice in writing, and the power and duty to review in advance and to certify the legal sufficiency of all legal actions and legal consequences to all governmental entities. We do have, and since my colleague, Ms. Hankins, has provided such a wonderful expose on the subpoena power, we oppose expanding the subpoena power because the ACLU believes it's necessary to ensure that sufficient protections are provided to subpoena recipients, as well as examine whether the establishment of this power within the OAG would result in unfettered authority. We testified in opposition in 2009 and in 2013, and now again in this proposal against expanding these powers for the Attorney General. And with that, I stand for any questions.
Thank you for your testimony, Ms. Hopkins, Maxwell. And I want to thank each of the witnesses for their testimony. I do have a few questions. And I'm going to start with you, Mr. Cook, and feel free to weigh in, Ms. Hankins or Ms. Hopkins, Maxwell, because I think each of your testimony touched on it. And it has to do with legal sufficiency. That's one of the points of contention between the Mayor's Office of Legal Counsel and the Attorney General's Office. And I believe you said, and I'm not quoting here, but I'm paraphrasing Mr. Cook, that the responsibility, that legal sufficiency is responsibility under the charter of the Attorney General. Now, I'm sure you know, and you weren't stating that it's a part of the charter or in the code, because it's not enumerated in the code specifically with respect to legal sufficiency. Legal opinions are in it, but not legal sufficiency. Do any of you think that legal sufficiency should be somewhere in the code expressly enumerated as the authority of the Attorney General, rather than relying on the common practice that's been in place for quite some time? And what does legal sufficiency actually mean?
That's my point, where I was about to start. I think the definition of legal sufficiency is sufficiently nebulous that trying to define it in the statute for all time is kind of problematic, which is why I believe the code and the charter actually says that the Attorney General is responsible for all law business of the District of Columbia, which is a much broader concept and encompasses a lot of different things. Once upon a time in the district's life, there was a line on documents reviewed for legal sufficiency, and the document was signed by someone from the Office of the Attorney General or the predecessor Office of the Corporation Counsel. It's an evolving concept. It's expanded from those simple reviews to make sure that you've met the proper legal form or format for a document, something as simple as literally a deed, but it's more complex than that in terms of compliance with local and federal legislation to make something happen. So I think the effort to enumerate legal sufficiency in the charter, in the DC code maybe, is not all that useful, because it's going to grow from where it is now to something else, and then we'll have a gap. So I think law business or law business of the district is a broad enough concept.
And do you, and feel free to weigh in if you all would like, do you feel like, and I guess you said this in so many words, that the authority to certify legal sufficiency is encompassed in the authority that is in the charter with respect to the Attorney General having domain over the law business of the city?
Yes, I do. Yes, to answer the question directly, yes, because part of the reason that the review is taking place by a lawyer is that you're asking the lawyer to provide some legal advice as to the appropriateness, the propriety of whatever the document is, the piece of paper are, and that's the law business of the district.
Did you want to say something?
So this is my world. I don't do business. I don't know other areas in which the Attorney General would be opining on the legal sufficiency of something. So I could be procedurally wrong about stuff. When I watch council meetings, you all ask your own general counsel, is the document, is the bill technically and legally sufficient or whatever? And that lawyer says, yes. So that seems to me one possible problem with defining it as the role of the Attorney General, because you have a general counsel that also weighs in on that. My position, the position of the Public Defender Service in this was, these types of hearings, it seems to me, getting an opinion on the legality of a bill, in addition to the wisdom of it, is important. And lawyers disagree about things, but that the council would benefit from hearing from that. And to the extent the Budget Support Act says, you'll go tell them whether it's legal sufficiently when I let you go tell them, that seems to me that deprives you all of more lawyers saying, you know, it could be read this way. When my office when we were sort of talking about the elected Attorney General and I was trying to explain to our different divisions, there's going to be this new person and I don't know how it's going to work. And they sort of say, well, who do we talk to? We're one of the counsels in the Jerry M litigation. We do special education litigation, we don't get funds from remuneration for it, but we do represent our clients in special education, and that's sort of against the lawyers who are at, I think, OSSI, but if we were going to appeal it, it would be the OAG. And it does concern me, and I do find it confusing, and I think it is implicated here of, well, if ultimately the Attorney General is going to have to defend litigation, defend against a suit, then wouldn't it be helpful to the agencies, wouldn't it be helpful to this council to have gotten their opinion on here's what's lawful, here's what's not, here's what's exposing the district, here's what's not, because they're ultimately the ones that are going to have to defend it. The council is going to act how the council is going to act. They may reject the opinion of the Attorney General because your general counsel says, nope, here's what we think is legally sufficient.
Here's what I'd like to know, though. Do you all foresee any problems with, because the mayor's is asking for the authority of, is asking to give the Office of Legal Counsel the authority to also issue legal sufficiency certifications upon request, and then saying that the Attorney General should be able to do the same thing upon request. Now, the Attorney General may decide to do it to a sponte without a request from the mayor. If you got two competing legal sufficiency reviews, do you foresee that being problematic?
I think it's extremely problematic. As I said before, if what I do now is not governmental, it's transactional in the world. And if I'm trying to do a transaction, real estate deal very generically, and there's a legal sufficiency review from the folks in the MOC, but I know that there's this possibility that the Attorney General may sua sponte or be asked by the mayor for an opinion that's different, why am I having a conversation with people who can't give me the ultimate answer? It's inefficient. If we've got to do this twice, it just doesn't make sense. So I think it's extremely problematic from just a practical business conducting sort of methodology. Why am I having two different voices on the same topic?
I'm sorry, let me just be super precise. I think there's a difference between offering an opinion on legal sufficiency and certifying legal sufficiency. So it sounds to me like what Mr. Cook is talking about, and it makes total sense to me, that where it has some import, that it has been certified legally sufficient, it does seem to me problematic that you could have more than one lawyer speaking for the district and they could reach different conclusions to certify. Where it's not certification, like offering testimony before the council on an opinion on legal sufficiency, I think it's fine to hear from the mayor and from the Attorney General. They may give different opinions. But it does seem to me that when it comes to having legal force and being certified as having as a legal force, I do think that has to make a decision. It's got to be one voice speaking and having the power to certify.
Let's say that the status quo remains, or at least the practice that had been in place, where the Attorney General is involved. And let's take, for example, the work that's being done by the OAG attorneys who work with the Deputy Mayor for Planning and Economic Development on these complex property transactions. And and I'll flesh this out once we have our government witnesses up here, but and perhaps, Mr. Cook, you can speak to your experience. I know it's been a little while, but my concern is, even if it were to stay the same and that the Office of the Attorney General would be a part of, sort of perform this legal sufficiency review, or at least be involved in the crafting of these agreements along the way, if the mayor decides that, hey, we've got attorneys, we've got top-notch attorneys in our Office of Legal Counsel, we're going to have them work on these transactions with the Deputy Mayor's office, and we'll concede that that the Attorney General will continue to do the certifications of legal sufficiency. But we're going to wait to the end of this process and then hand it over to the Attorney General. Would that be problematic, or do you think that, I guess my question is at what point, even if the mayor agrees that the Attorney General should be involved, at what point should the Attorney General be involved in these complex real property transactions?
Sure. Not an easy question to answer. I mean, and it's sort of a problematic premise. And in a complex transaction, my personal view, not a legal requirement, I don't believe, but my personal view is that it would be prudent to have the people who ultimately sign off on it involved from the very beginning. Transactions are iterative, they're dynamic. The legalisms involved come in and out. They are more or less important depending on what phase you're talking about. It makes sense as a practical matter to have the lawyer who's going to sign off on it ultimately involved from the beginning to the end. Now, there's no requirement that that happen, but this hypothetical is problematic in my mind if you don't have the lawyer who's ultimately going to sign off on it involved from the beginning, and you come to 95% completion and you give it to him or her and say, okay, this is the deal we've negotiated. We're real smart lawyers. We're really good at this, and we think it's okie dokie. Here it is. Please say yes. Do your magic. There is tremendous practical pressure on the person at the end to not overturn the apple cart. Now, that doesn't mean that the people who did this were necessarily Machiavellian or wrong. It just means you aren't getting my best legal advice. You're getting ad hoc. You're getting advice at the point where it is, as opposed to what I would have done at the beginning. And as my colleague here at the table said, lawyers can agree or disagree about all kinds of things. Doesn't make it legal or illegal. It's almost as though the mayor would say, in your hypothetical, I've got some really smart budget people here. I don't need to listen to the CFO. I can do this deal until I get to wherever I want to because I got some real smart financial people. CFO sign off on it now. Doesn't work that way either. So I don't think that it's useful to approach it that way. I don't think there is an absolute legal impediment to approaching it that way. I just think it's very inefficient. And again, if I know that I've got to get this AG signature at the end, and I spend 3 months or 4 months doing the deal talking to somebody who isn't that person, I want the AG in the room. Because what I don't want to do is to have to renegotiate my deal 3 months later.
And I've heard that concern raised in the past with folks who I've spoken to. Here's the issue, though. Let's take the current office holders out of the equation.
Sure.
Just put anybody in that position. And at any point in the future where the position is elected, and if you're only relying on the practice that's in place, essentially a gentleman's or a gentlelady's agreement that I will involve you in the process, it could change any day. I mean, you can have a mayor that says, okay, we're not going to involve the Attorney General's lawyers in the process. Should this be somewhere enumerated in the law that this practice should continue the way it is, or should we just rely on that practice and hope that the good judgment of the person who's elected will play out where they're involving these really smart Attorney General lawyers who are used to doing this work in the process from the beginning so that we get the best product in the end?
Right. I should be clear. I was going along with your hypothetical.
Right.
I don't believe that construct is correct. I believe that the law already requires the Attorney General's participation in all of the law business of the district.
Under the law business concept that is in the charter,
That's
do you
right.
think that it encompasses the requirement that these OAG attorneys be a part of this process from the beginning?
Right. And again, and this is all kind of difficult to define. If you go to a meeting with a real estate developer and the deputy mayor for economic development is talking about this deal and possible transfer of land or utilization of district land or land in the district, if there are no lawyers in the room and you're talking about the deal conceptually, no, you don't need OAG lawyers sitting there. You don't even need the DPED lawyers sitting there. But when the other side brings lawyers, when a document is being crafted, when a transaction is being structured from a legal or financial point of view, then I think you need lawyers involved. And then I also think it's prudent to have the Office of the Attorney General lawyers involved at that point. Now, that may happen very early in the
Well,
conversation, may happen late.
let's take out whether or not it's prudent. I want to know whether or not the law requires it, because you said you need lawyers involved. Yeah, you could have the mayor's got her lawyer, and her lawyers and can be involved, and they're doing this stuff. But
No.
do you think it's required,
Right.
given that the authority to conduct the law business of the city rests with the Attorney General, is it required that the Attorney General lawyers be at the table when these legal transactions are taking place?
Short answer, yes, because the mayor doesn't have any lawyers. The only lawyers in the District of Columbia are in the Office of the Attorney General. The mayor has people who have law degrees. The mayor has people who can give her legal advice, but the mayor doesn't have any lawyers. The corporation has lawyers, and the corporation's lawyers are the Office of the Attorney General.
Okay. Okay, I want to ask you all before I go to the next panel. I know we've got a lot of witnesses, but I wanted to make sure I could flesh some of this stuff out with you guys. The mayor's proposal also would change. Well, I don't know about change, but it would codify a lawyer-client relationship between the mayor and the attorney general. Do you think that this, and I think you testified to this, Mr. Cook, is this legal under the charter?
I don't know, because I don't understand what that means. As I said before, the construct, as I understand it, municipal corporation chief executive officer, municipal corporation has a lawyer, it has a CFO. So the municipal corporation's lawyers are in the Office of the Attorney General. I don't know what that means. I just haven't talked to anybody on the mayor's side or whoever wrote the legislation side to quite understand what that means. I know as a member of the bar, if you hold yourself out to be a lawyer and a person relies on your legal advice, that's an attorney-client relationship, but I don't know what it means in this context.
And one of the things that, and I'm trying to find it in my notes, that the law speaks specifically to the Attorney General, and it speaks to this sort of concept of the public interest. And I can't find it right now, but
Can I
I
just
think that's part of the tension. Sure, Ms.
make
Hagan.
a quick note as I was sort of looking through an excerpt of the Budget Support Act?
Sure.
I don't know what this stuff means either. So I did note in the preamble, it talks about clarifying the relationship of the Attorney General and Mayor is that of attorney and client. And then later, amending 1301.81, it talks about in all law business carried out by the Attorney General, relationship between the district government and the Attorney General shall be as client to attorney. And is the mayor the district government? Is the district government separate from the district?
So we'll have to ask those questions. And,
Okay.
and I know one of the things that's specifically laid out in the referendum was this notion that the Attorney General shall be responsible for upholding the public interest. What does that concept mean to you all? Upholding the public interest versus perhaps an argument that the Attorney General, the mayor there'd be an attorney-client relationship, which they're asking us to actually spell
Sure.
out.
I think that part of that language relates to a sort of expanding or redefining the role of the Attorney General, that he or she is not simply responsible to be the lawyer for the municipal corporation, but he or she has responsibility to the larger public, so that there is this public interest that he or she must also discharge, as well as simply representing the interests of the corporation.
Okay. All right, I'm going to move on to the next panel. I don't have any additional questions for this panel. I do want to thank you all for your testimony this morning.
Thank you.
Thank you. Thank you.
We could have Will Merrifield, staff attorney for the Washington Legal Clinics for the Homeless. How about Dorothy Brazil, executive director of DC Watch? Okay. Josh Williams, president, Metro Washington AFL-CIO. Paul Zuckerberg. Parisa Neruzzi, Executive Director, Empower DC. I don't see. Delvon Michael, Executive Director, DC Work and Families.
Good to see you again, man.
Mary Young,
Thanks for all your work.
Anti-Commissioner 3B04.
Obviously, and you're the right man. The right person to get it to.
Good morning, and thank you all for being here. We're going to start with you, Mr. Zuckerberg.
Thank you for having me here today. My name is Paul Zuckerberg. I'm an attorney in private practice, and I was also the plaintiff in the lawsuit that helped bring about the elected Attorney General. I'm here today to lend my voice in support of the office of the new Attorney General and to urge the council to give this office the tool it needs to be successful. We're embarking on a new era in the district with a new mayor and administration and many new and welcome faces on the council. It is important in working through the challenges we face that the council have the independent legal advice of an elected Attorney General. The review for legal sufficiency of major transactions has always been the chief duty of the Attorney General. The AG's office has been performing legal sufficiency reviews for decades and has the staff and expertise to continue to do so moving forward. To move this legal duty elsewhere risks compromising the soundness of the advice provided to the council. Long experience has shown the wisdom of independent legal review of important matters. Businesses and individuals would be remiss in entering into important transactions without independent legal advice, and so would the council. An independent lawyer will give a client the advice he needs to hear, not the advice he wants to hear. Of course, the review provided by the Attorney General is for legal sufficiency only. Policy decisions are made here in the council and administered by the mayor and the agencies. But everyone benefits when proposed legislation, rulemaking, and contracts are independently assessed. Relying on the AG's office early and often is the best assurance that government actions have sound legal footing and that the council's priorities are not delayed by needless litigation. Proposed legislation which alters the core duties of the Attorney General runs the risk of undermining the authority of the office and depriving the district of a unified voice in legal affairs. I urge the council to take this opportunity to reaffirm the independence of the elected AG and embrace the benefits independent legal advice can provide.
Thank you for your testimony. Mr. Williams?
Thank you. Thank you very much, Councilmember McDuffie, and good morning to you. My name is Jocelyn Williams. Is this on? Yeah, it's on?
Yes.
Yeah. My name is Jocelyn Williams, and I'm the president of the Metropolitan Washington Council, the umbrella group for 170 unions here in the District of Columbia and in the Metropolitan Washington area. I'm here today to testify on an issue which is very, very important to what I consider to be lay individuals. The nuances that you will probably be engaging and discussing today, many of those will be above the head of myself and many of the people that went to the polls to elect an independent Attorney General. So I would ask you not to lose sight of the opinions of lay individuals and get too much into the weeds and the verified discussions that attorneys will be discussing today. I would begin by saying it is critical that DC, like 43 other states with elected attorney generals, fund and maintain an attorney general's office that is insulated from politics, from the whims of the executive and legislative branches of government, and from special interest pressure. The District of Columbia needs an Attorney General office that can conduct independent legal reviews of executive branch actions, can provide legal sufficiency reviews of contracts, legislations, and regulations, and can take actions in areas such as consumer protection, the environment, health, labor, and ethics when necessary to protect the public interest. And I emphasize and repeat again, to protect the public interest. This is what the voters of the District of Columbia voted for in 2010. We ask that the council strengthen the office and ensure that it remains independent and adequately funded so as to maintain the public welfare and confidence of the citizens of the District of Columbia. Thank you very much.
Thank you for your testimony, Mr. Williams. Commissioner Young?
Good morning. Thank you very much for having this hearing, this roundtable. I'm not an attorney, so I always approach things from a very practical, how we live this out. I think when we had the election, it became the will of the voters that the Attorney General's office should be independent. And therefore, I think that both the legislative and the executive branches of our government should honor that. Citizens need to have confidence in the office of the Attorney General and the work that it does. I personally have concerns that the mayor seemingly is amassing a lot of power to her office by establishing the mayor's office of legal counsel. To me, it seems far-reaching and denudes the office of the Attorney General of some of its powers. That is, providing overview for legal sufficiency reviews of legislation, regulations, and contracts, issues related to hiring attorneys for the different agencies, and giving advice to the mayor, but only at her request. To me, that is divisive. I believe the Attorney General is not only the people's attorney, but that person is also the legal authority and voice for the District of Columbia government as such. I began paying attention to DC government and how it operates when I watched several hearings with the previous Attorney General who was appointed by the mayor. One of the most uncooperative persons I had ever seen, and also treated the council with disdain. We do not want to return to those days. There needs to be 3 separate but co-equal branches. What I see as possible problems stem from the fact that person who is the Attorney General, if he or she is not independent, can jeopardize the performance of their duties. That person will be subject to carrying out the desires of his or her boss, if not independent. We need clarity for the Office of the Attorney General and the responsibility to conduct legal sufficiency reviews, further confirm the AG's independence in reference to personnel and procurement, and it needs to clarify subpoena authority in investigations, not only for the current AG, but also for the future. Since we have the first elected Attorney General, now is the time to clarify how this office is going to operate in the public interest, also vis-a-vis the legislative and executive branches. The independence of the Office of the Attorney General is vital in protecting the public interest, as well as establishing the confidence of the public that this will happen. Thank you.
Thank you for your testimony, Commissioner. I'd be interested, and obviously all 3 of you, I want to thank you for your testimony here this morning. But as 2 non-attorneys, and you know, my staff and I have been mindful of not trying to get too far into the weeds, but knowing that it's necessary for us to really figure out whether or not the current construct is working and will work in the future, taking out the people who currently hold those offices. I agree that the will of the people is important. We elected an independent Attorney General, and that person should have the tools that he or she needs to be able to fulfill that mission and that mandate. That said, you know, what's your opinion of the transition to the elected Attorney General so far? It's only been more than 100 days, but how do you think things are going so far?
Well, as ANC Commissioner, we had a representative from the Attorney General's office come and speak to our commission. And I'll be honest, in the first time that this has ever happened, it has become more of a bond between the DC government in its judicial branch, in its judiciary branch as far as the Attorney General is concerned, and the public. The Attorney General is the people's attorney, just as the Public Service Commission has an attorney that is, or the Office of the People's Counsel, is the people's attorney for utilities and matters. So we need to have this confidence that this office is going to be independent and will listen also to what the people need and want. We need to have this. It's the right moment to do this, and let's do it right since we have this moment. I am not that familiar with how the previous Office of Attorney General worked. I am only knowledgeable of what I had seen happening in the past and not happy with it because it was not necessarily what the people wanted. It was really coming out of the executive branch. And this was before you were on the council, so I'm not certain if you ever had any experience of that, but it was not pleasant. It was a very unpleasant experience for all DC residents.
One of the things that DC voters voted for, at least the language that was in the referendum, said that the Attorney General should be responsible for upholding the public interest. What does that phrase mean to you all, upholding the public interest? Any of you all can speak to it, Ms. Zuckerberg or anybody else.
Well, I think
You
that
ran for the office, so I know you probably have an understanding of what you thought it meant.
I think I understand what it means. The Attorney General is the attorney for the municipality, and the mayor is the chief executive of the municipality. And so there is that attorney-client relationship, and in 99% of the time, it's going to be a normal attorney-client relationship where the attorney is advancing the objectives of the client. However, it's not just, you're not just the mayor's lawyer. You're something more. You have a wider obligation, not just to get the best results for your client. If it conflicts with the charter, if it conflicts with settled law, if it conflicts with the contracting regulations or the land use regulations, you have a duty to uphold that as well, and sometimes to tell your client, this is not, it cannot be done this way. So you sometimes have to be the bearer of bad news to your client and not simply advancing the interest. And it's something that has to be balanced. It's not going to be the same on everything, and we depend on experienced and qualified attorney generals to be able to balance those two interests.
Did you want to add something,
Yeah.
Ms. Williams?
I'm going to posit a layperson's answer to that, without getting into the nuances of the mayor and the city council, all of whom in my perception have their own attorneys, general counsel, the council, and then you have the mayor has a general counsel. I look upon the attorney general as a people's counsel, period. The people's counsel. His or her responsibility is to protect the interests of the general public, which means that on issues involving consumer rights, health, the ethics of the government, that person is supposed to weigh in, regardless of the position that the executive takes or the legislature takes. His or her responsibility is to advise the general public. This is how I see it. And regardless of what may take place in the court of law, it is something that I will hold in my mind the next time an election comes around and I'm judging elected officials, including the Attorney General. I want somebody who's able to tell me how my mayor is conducting herself legally and ethically. I want somebody who's able to defend my interests as a consumer, regardless of the political issues that may be taking place. I want them to go in and I want them to say, I'm representing your interests. It may conflict with the governor or the mayor, but I am taking your interests into consideration and this is the reason why. And I am then able to make that judgment based upon that person's advice.
Okay.
And, I'd just like to add one thing. As a longtime tenant advocate, if we would have had the possibility of going to the Attorney General to cover some of the issues that relate to some of the unscrupulous practices of landlords, we could change a lot of things. We're trying to do it through the legislative, which we're not, after many, many years of this kind of, we're not getting much help. Because if we can change some of the laws that would help the tenants, that would be positive, but it's not happening. It just gets moved ahead session after session. If we could go to an Attorney General and say, this is the problem that we are having, and you as Attorney General are our counsel, what can we do to move these legislative laws forward? How can we address them? We need attorneys' help, and we don't have money to get attorneys, but this is our attorney. And so we feel really that this person should be totally independent from both the executive and legislative, so we can turn to them for help. That's public interest.
Well, I do appreciate each of your testimony here this morning. Thank you. Could I have Cynthia Poles? Joseph Martin, Commissioner NC 4C09. Brenda Richardson. Hello and good morning to each of you. I appreciate you being here this morning. We're going to start with you, Ms. Poles.
Good morning. My name is Cynthia Poles. I'm a private citizen, but I'm also president of my tenant association, so some of my thoughts about the AG's autonomy are colored by that perspective. I want to say, it's kind of appalling that just a few short days into our first Attorney General's days on the job, we have this rather aggressive move by our mayor to strip the Attorney General of much of his basic powers. I think that I would urge the council to reject Subtitle E of Title I of the Budget Support Act. It's just untimely, not appropriate to be trying to change things before we actually have had any experience really with the independent AG. I mean, we approved this, the voters did, by 76% majority in 2010, and we elected Carl Racine Attorney General. He took office on January 2nd. So we're very early on. But when we took those actions as voters, we wanted an independent, autonomous Attorney General, a legal watchdog. As many of the other speakers have so well articulated, it's very clear from the language that he has full authority over all the district's legal business. I'm sort of perplexed as to why there's confusion as to what that means. I think if anything, we should be looking at in the other direction, looking at the bill that Mr. Racine has put forward, B-21-139, that addresses some of the enhancements that their office is sensing they may need at the beginning of their tenure. So if anything, we should be looking in that direction instead of looking in the direction of taking away powers. I think in particular, I like the idea a lot of the $20 million Consumer Protection Fund that's in his bill that would enable the office to more aggressively and with financial certainty pursue those public interest questions that we were talking about in the earlier panel. There are a multitude of them. There are so many DC laws that are enacted that have good objectives that they often don't seem to get implemented from the consumer perspective because the agencies fall down on the job and allow things to not be implemented that should be implemented. So I guess that in my concluding point would be that we need to strengthen that office, not weaken it. It's not an attorney-client relationship. In my other life, I am an attorney, and when you're the attorney, you may think you're powerful, but in the end, it is the client that decides So if you put that relationship into the law, you are basically making the Attorney General in effect subordinate in some way to the rest of the DC government, when we want the Attorney General to be powerful and autonomous and independent and an equal voice with the mayor and the council. I'll wrap up since I've run out of time, but I'm available to answer questions.
Thank you for your testimony, Ms. Bowles. Commissioner Martin,
Good morning, Mr. Chairman.
if you could press the button. There we go.
Good morning, Mr. Chairman and members of the committee. My name is Joe Martin. I'm an ANC Commissioner on ANC 4C in Petworth. My testimony is my own. I'm not here speaking for ANC 4C. ANC 4C has not taken a position on the issues at hand. And I knew you'd be hearing from the lawyers before me about the technical details of the bill, and I responded to the proposal more on a political basis and as a longtime resident of the city. When I first heard of the mayor's proposals to undermine, in my view, the Office of the Attorney General, my instinct told me to review out of curiosity the referendum vote tally that led to the creation of the office and the vote totals for all the candidates who ran for Attorney General last year. As you probably know, in 2010, over 75% of the votes cast, 90,318 votes, favor the creation of the Office of the Attorney General. Last year, 177,358 ballots were counted in the Attorney General's race in the November 4th general elections. 90% of the votes cast favored the 5 leading candidates for that race. The numbers in those 2 election cycles tell me that the voters have very strong feelings about the need for an independent Attorney General. One of my first reactions when hearing of the mayor's proposed changes to the role of the DC Office of the Attorney General was to ask, what's the rush? How much thought has been put into this? How well has the mayor's position on this issue been vetted? And where did this come from? A central reason that the voters acted to create the Office of the Attorney General was because of the perceived lack of independence by the former Attorney General Peter Nichols, who served under Mayor Adrian Fenty, as you know. Has that lesson been forgotten? All the candidates running in the Ward 4 special election this month, including Brandon Todd, have said they favor a strong, independent Attorney General. They were asked specifically about the mayor's proposals on this issue and are on the record on this. I grew up in Massachusetts in a political culture where the elected state's attorneys general played a vigorous, independent role in the affairs of the state. Elliot Richardson and Edward Brooke are 2 who served in that capacity who came to mind as I was preparing this testimony. As we know, they went on to play much larger roles on the national and international stage, in part because of the leadership they displayed as independent attorneys general elected by the people of the Commonwealth of Massachusetts. Expecting an attorney general to be strong and independent is an inherent part of my own political DNA. Mr. Chairman and members of the committee, I, as a voter and 30-year resident of DC, am counting on you to protect the interests that the voters clearly expressed. I believe Mayor Bowser is doing a superb job in many areas. On this particular issue, I feel the mayor has been poorly advised, her actions unwise. I want the Attorney General to have the powers to act strongly and independently in the public interest. I believe the majority of my fellow voters want exactly the same. Thank you for your time.
Thank you for your testimony, Commissioner. Ms. Richardson?
Hi, Mr. McDuffie.
Hello.
Good morning, Councilmember McDuffie and other folks up on the dais. My name is Brenda Lee Richardson. I'm a resident of Ward 8. I am here today to support an institutionally independent office of the Attorney General. I am proud to say that I was one of the 76% of the DC voters who voted for an elected Attorney General for our nation's capital, which allows Carl Racine, a fine, honorable man of immense integrity, to uphold the public interest without any political influence. I am a strong believer in checks and balances. It keeps folks honest. Institutional safeguards are critical to ensure that the OAG is always able to work autonomously to protect the public's interest. From what I understand, Mr. Racine's office is not quite there yet. I wholeheartedly support the OAG's proposed legislation with the following goals: being consistent with the will of district voters, being consistent with the policy set forth by the DC Council, and creating a top-tier state attorney general office. If the DC government is on the cusp of functioning as a state, at a state level with every department, then why can't we allow the Office of the Attorney General to exercise his power or her power to do the same thing? We, as citizens of the District of Columbia, do not have a spirit of fear, but of power and of love for our city and a sound mind. This is a democracy, and the people have already spoken, Mr. McDuffie. And to that end, at the end of the day, the OAG is the defender of the residents of Washington, D.C. He needs to have all the necessary tools at his disposal to protect our interests. I actually find comfort in knowing that this office now exists. And let me tell you about what I think public interest means. This office has been visible. It's been very communicative. It's got a great communication system. They are reliable. The community trusts them already, and they're really, really good at relationship building. I've been to a meeting outside of my ward where they've been just as visible. So I just think it's really, really important that he has the opportunity to do what he needs to do. Thank you.
Thank you, and thank you each for your testimony here this morning. Just a couple of quick questions. I believe, Ms. Poles, you said that you sort of characterized the mayor as stripping the AG of powers. And I wanted to get your sense of what powers you feel like the mayor in her proposals are being stripped away from the Attorney General.
Well, there's the one that's been talked about the MOLC, giving that entity ascendancy in terms of the legal sufficiency. The other thing I think is this general blurring of the lines by this predicate that it's an attorney-client relationship where you're creating ambiguity as to the standing of the AG and the AG's ability to speak independently of the rest of the government. So I sort of see that as a slippery slope to codify a notion of it being an attorney-client relationship, even though that sort of has a little bit of sort of surface appeal. I mean, as an attorney, I know I'm not the one who ends up calling the shots when the client wants to do other than what my advice is, regardless of how sound my legal advice may be. So it just seems a dangerous direction for that to be injected into the set of legal rules that govern the office.
Don't each of you, though, think that the mayor should be able to implement her agenda? Obviously, the Attorney General is the chief legal officer of the District of Columbia, correct? So if you read what the charter says, it says the Attorney General for the District of Columbia shall have the charge and conduct of all law business of said district. So he's the chief legal officer of the district. But at the same time, the mayor is the chief executive of the District of Columbia government. So don't you think she should have the authority and ability to conduct her agenda as well if she's got lawyers in her mayor's office of legal counsel? I'm sort of playing devil's advocate to get your sense on that.
I think that the people should be able to implement their own agenda. Because
And isn't that why we elect the mayor?
no, but I mean in the sense that we voted, and there's power in our vote. And if we voted to make this happen, then I think the people have already spoken, and I quite don't understand why we're here if the people have already spoken through their voting rights.
Amen. All right, well, we're gonna ask folks not to slow this down by demonstrating. So I think a very important question is then, if the mayor wants to implement a program or a policy, and it involves a contract, in your opinion, given the vote that you all cast for an independent attorney general, should the attorney general have the authority to simply certify the contract as being legally sufficient, or should the attorney general be able to say, wait a minute, I've got a problem with what the mayor is trying to do with this program or this policy. The public disagrees with the mayor moving in this direction.
That's a tough question, I think, because sometimes our laws are ambiguous, and there isn't a black and white piece of legal advice you can give on whether or not a contract is appropriate. I would say we would want that Attorney General to stick to the legal aspects of things and not to get into policy making where the policy question is not clearly unlawful. He may not like the contract, but if it's consistent with the DC law, he probably shouldn't be saying no for policy reasons, even though we might like, as members of the public, we might like to have that extra voice in there on policy stuff. I think you're correct that in a democracy, we have elected the mayor to establish policy. We've elected the attorney general to implement the law. So you do need to be aware that there sometimes is a line between the two, and there may be policy stuff that you don't like, but it's not a violation of the DC law. But I don't know that you need to get into drawing that line. That should be something that you as the council, that is something that the attorney general should be aware of as he provides advice on contracts and the like.
Okay. I do appreciate you all's testimony this morning. It's been incredibly helpful. Thank you.
Thank you.
Treyon White. Emmanuel Lipscomb. Laura Jackson. Laura Jackson is not here. Oh. M. Beverly Hunter. Tyrone White. Good morning to each of you. We're going to start with you, Mr. White. Or actually Treyon White, because we've got two Mr. White at the table.
Good morning, Councilmember McDuffie and other representatives on the council. And my name is Treyon White. I'm a resident here in DC, more specifically Ward 8. I'm here today in support of an independent Office of Attorney General. I believe the OAG should execute full powers of its office. I believe Mayor Bowser proposed to have her staff attorneys to provide legal reviews of contracts, city laws, and other matters. When indeed, as you heard before from other testimonies, that over 70% of the voters clearly voted that we wanted an independent elected attorney general. Residents in DC, as I go door-to-door campaigning, are losing faith in DC's elected officials. So it's incumbent upon us as elected officials to restore public trust to the people and do what's right. It is vital to the council to adhere to the will of the people. We also ask for additional powers to be restored back to the Office of Attorney General. This country is supposed to be built on checks and balances. As long as the council passively deals with these matters, it weakens the faith of the people and our fight for statehood. DC Council is in a unique place to do what is right, and Chairman Minister introduced legislation that leans towards the will of the people, including the ability to review and certify legislation, control legal settlements under $1.5 million, and issue formal opinions binding all government entities. And as DC residents, we are asking the council to restore checks and balances to DC residents. Thank you.
Thank you, Mr. White. Mr. Lipscomb?
Yes, my name is Emmanuel Lipscomb. I'm a resident of Ward 4, the native-born District of Columbia. It's wonderful to be here before you, and in fact, it was this issue that actually made me stop sitting at home and doing my other things and say, well, it's time for me to come out and start talking. We say that citizens of the District of Columbia should have statehood. On DC.gov, it is written, statehood is the most appropriate mechanism to grant the United States citizens who reside in the District of Columbia the full rights and privileges of American citizenship. These rights not only include equal representation in the United States House of Representatives and the United States Senate, but also full control over local affairs. Today, I come not to discuss with you the right or wrong of legislation in front of you, but instead I am here to sound the voice of citizens, the residents, your constituents in the District of Columbia. Let us go to our history. In 1871, Congress created a territorial government for the entire district, which was headed by a governor appointed by the President of the United States for a 4-year term. Due to alleged mismanagement and corruption, including allegations of contractors bribing members of the district legislature to receive contracts, the territorial government was discontinued in 1874. From 1874 to 1967, the district was administered by a 3-member board of commissions. In 1967, President Johnson was granted by Congress the right to appoint us a mayor and a city council, which would lead the citizens of the District of Columbia being given the right in 1975, just 40 years ago, to elect by popular vote our own administrative officials, which concludes today in us having the great mayor and the great city council that we do have. You see, along with the position of governor, the only top state executive position that exists in all 50 United States is the Attorney General. Of the 50 seats, 43 of those are elected positions, but this isn't the rationale that I'm really here to discuss. You've read it. Law 18-160, the Attorney General of the District of Columbia Clarification and Elected Term Amendment Act of 2010 was introduced in Council and assigned Bill number 1865. I could go on with that, but you know it. So let me just summarize. That went to the House. It went to Congress. It got approved. And it was ratified by the electors of the District of Columbia in a general election held November 2nd, 2010, and certified by the District of Columbia Board of Elections and Ethics on November 29th, 2010. Section 201 became effective as law on May 28, 2011, following 35 days of congressional review and assigned law number 18160A, section 201, as a new section 435 to the Code of the District of Columbia Home Rule Act.
Mr. Lipscomb?
Yeah.
I know you've got a lot more to read in your testimony, but your time has expired.
Bottom line, we voted for you. You asked before, you said, what is the relationship? We look at you all as you all create the laws and administer the law. The mayor is the CEO, but we as citizens of the District of Columbia, we're the shareholders. And the Attorney General represents the legal interests of the shareholders of the city.
Thank you.
Thank you.
Mr. White?
Yes, my name is Tyrone White. I'm born and raised in Washington, D.C., come out of public schools, graduated from McKinley High School. I lived in Ward 8 for 50 years plus. But at any rate, the reason I'm here today because I elected the Attorney General. I elected you all that are on the board today to represent us. But the Attorney General is going to elect, and it's for the people as well as you all. He's going to keep no difference in what he's going to do. He's going to serve us just like he's going to serve y'all. But it's going to be one way, the Attorney General's way, because we done seen too much going on with this council and the mayor, with the different bills they have produced, things they have produced created corruption and so forth. And and sir, it's really mind-boggling to watch y'all on TV how things go down. And you know, you look around you, here you come back again. You need somebody to straighten it out. I mean, it's sad. It's very sad. I watched a lot of this. And like he says, the first time I came out, because you know what? I done got tired of seeing all this from Mr. Fenty and Gray and stuff. You know, I done really got tired of seeing all this all the time. All this misconception. You leave, money going this way, money going that way, profit we're losing. Miss Henderson ain't doing things right with the school bit. Kids gotta ride the bus. I mean, there's so much going on today that's wrong. You close the school, give it to the charter school people, however it's done. I'm trying to make a long story short, and you know, that's sad. Then these kids gotta go way across town to somewhere else to go to school again. I mean, you know, where's this got to go? When I was born and raised here in the district, you went to school in the community you lived in. You didn't have to go across town. A school was in your community. I went to Stevens Elementary, which almost like no longer exists. That community is gone. Talk about them. But I'm saying to you again, sir, it's just sad how this is going on. We elect the Attorney General for the people, by the people, and of the people. And I'd like for him to serve and do his. We don't need without this transparency, we can't work. You need transparency, accountability. All that has to go hand in hand. That's come through the Attorney General. He has to do his job. Let y'all do his. Do y'all. Well, let him do the job that he was elected to do, to serve us. That's all I got to say, really.
I want to thank each of you for coming down this morning to testify. I want to just clarify one thing. Mr. Trayon White, you said that in your testimony that there are additional powers that should be restored back to the Attorney General. Which powers? I wasn't sure if you were referring to the bill that the Attorney General sent down, which would add and enhance his authority, or you were referring to the subtitle that the mayor had in the budget that would have expanded the mayor's office of legal counsel to give them certain responsibilities that are currently being performed by the Attorney General.
So what I meant by that is that now there are lawyers who are in independent agencies that's supposed to be under the Office of Attorney General that he really has no jurisdictional authority over, that, you know, oversee these agencies.
Okay.
So restore means they need to be in his preview. You know, we need to have those lawyers that's in those offices responding to the elected Attorney General, which we don't have at this
So
point.
you mean the idea that the mayor, the council voted to create the mayor's office of legal counsel, which sent some of the attorney generals, the assistant attorney generals from the AG's office over to be general counsels and agency counsels under the purview of the mayor as opposed to the attorney general. That's
Yeah,
what
the
you're
Attorney
referring
General needs to have
Gotcha.
oversight over those lawyers.
Okay.
Absolutely.
I just wanted to clarify that. I do appreciate each of you all providing testimony. I agree, Mr. White, that this is about transparency and accountability,
It really is,
which is one of the reasons why we're holding this roundtable.
But that's why I come out here today, sir. You know, I sit back, I watch many a hearing on that. I seen how Mr. Catania was talking to one of the witnesses just like myself. And a job so been done by a contractor, right? They done give up $2 more million to this contractor. And this lady went in there or something and saw this guy hadn't done none of the work. But none of y'all had nobody to oversee that. Now, if that lady hadn't told Mr. Catania about that, now that's $2 million going down the tube. So, I mean, when you don't have this kind of oversight, sir, it is very bad when you see some of these incidents that took place on this television. And some people don't even want to come down to talk about it.
Well, I appreciate you
Just
coming
like my
down.
time coming down in there. I was down there before when they closed the number 11 Boys Club, which I fought for since 1963.
Which I played at. You talking about the one over
Right.
at MLK?
Right, yes, sir.
Outside the
When I
old
moved
Safeway
over
and
there,
MLK?
I lived in Trenton Park before I built my home on Raleigh Place. And you know what? I helped that Boys Club because 13 sent letters to me. Well, why don't you bring your contribution? I said, shit, because you don't do the right thing by number 11 Boys Club. That's why I don't put my contribution over there. They sent 2 letters to me, but you know, I just refused.
You know, that's probably a conversation for another day, but I will tell you.
I know it is.
I support the Boys and Girls
Well,
Club.
I'm telling you,
Wholeheartedly.
hey, I supported when my first son went there.
I played
You know?
I played basketball to number 10, I played
Yeah.
football to number 12, and I played
Right.
baseball for number 9. So
But
I'm a
I did
huge
some-
supporter.
I did some of that
of
all
Boys
over
and
the
Girls
city.
Clubs. Okay.
But I'm
all
just
right.
saying to you again,
I
that hurt me
appreciate
so
you
bad
all.
when Marion did that to the charter school. They killed the Safeway that was up there.
I remember
They
the
wouldn't even let
Safeway.
Safeway expand.
I remember the Safeway.
I worked for Safeway for 39 years.
Well, you know what? I'm going to invite you
Yeah.
back down so you can testify at another hearing that
Yeah,
speaks to
right.
those issues.
Yeah.
You clearly
I
got
know,
something
but
to say,
anyway,
so I
like
do
say,
appreciate that.
You know, it just hurts, you know.
Thank
We
you
need
so
the
much for your
We need
testimony.
the transparency, though, really.
I
We
agree
need the
wholeheartedly.
accountability, too.
No question about it. Thank you.
All right.
Thank you.
Next, we have Leona Redmond and Ariel Levinson Waldman. And that's it in terms of public witnesses. Was there anybody else who did not sign up previously to testify who wished to testify? If you could come up, sir. going to start from the left with Mr. Levinson Waldman. And good, I think we're still in the morning time. Good morning to each of you. Thank you for your testimony here this morning. Mr. Levinson Waldman.
Thank you, Chairman McDuffie. And good morning to the committee, to the staff members. Although I'm a proud servant in the Office of the Attorney General, I'm here today in my personal capacity. I've been asked and I've been authorized by former Attorney General Irv Nathan to read his letter to this committee into the record. Mr. Nathan is on travel and regrets he couldn't be here today. You also have a copy of that letter for the record. It's dated today. It's addressed to you. It states as follows. Subject, the proposal to remove OAG's independent review of the district's commercial real estate transactions. Dear Chairman McDuffie, as former Attorney General for the District of Columbia from 2011 to 2014, I write to share my views on the Attorney General Independence and Authority Implementation Act of 2015. In particular, I want to comment on the ongoing public debate regarding efforts of the current Executive Office of the Mayor to eliminate the Office of the Attorney General's independent review of major commercial transactions. I'm advised that under the Mayor's proposed plan, the lawyers who currently work on major real estate transactions for the district and are now in or are reporting to OAG's commercial division would all be included in the newly created positions within the Deputy Mayor for Planning and Economic Development, DEMPED. Doing so would be contrary to the considered policy choices reflected in this Council's 2013 legislation and would be unwise and counter to the public interest in the district. In anticipation of the district's first AG election, the district's executive branch during the Gray administration evaluated how best to responsibly transition from the unitary model with an Attorney General subordinate to the Mayor to a bifurcated model seen in 43 of our fellow states with, as the Chairman noted, the Chief Executive Officer and Chief Legal Officer each being elected, neither reporting to the other. The Office of the Attorney General, at the Mayor's request, in 2011 formed a task force that spent nearly 2 years examining this issue and developed recommendations for the Mayor, who ultimately submitted a proposed bill in early 2013. After extensive debate by this body, the Council passed the Elected Attorney General Implementation Amendment Act of 2013. Among other things, this act transferred supervision of agency counsel from the Attorney General to subordinate agency heads so that they would be within the mayoral reporting line and not that of the elected Attorney General, and so they could play a day-to-day support role of the agency directors while following the legal views of the Office of the Attorney General. As the then Attorney General for the district, I served as the witness for the executive in each of the related council hearings. In proposing these changes, the bill distinguished the legal work involved in handling the transactional functions in DEMPED, such as complex dispositions of valuable district properties to developers, from other agency council functions. The council, in its enacted legislation, while transferring the reporting lines for agency council, wisely and specifically left this OAG function and the personnel who perform it untouched. This choice reflected the council's recognition of the importance of having an independent legal analysis of our major real estate transactions and the bright line distinction between the day-to-day support functions of agency counsel and the type of legal analysis, as well as the pressures involved in DEMPED's transactions. To handle cross-agency coordinating, Mayor Gray's proposed bill called for, and the council then passed, a provision creating the MOLC, a, quote, small office, unquote, that, as Mayor Gray's transmittal letter explained, would, quote, report to the mayor and be responsible for cross-agency legal, training, and other issues associated with the agency council offices. That decision was designed to respond to the 2013 Act's transfer of supervisory control of subordinate agency counsel from the Attorney General to the agency heads, and to ensure cross-agency coordination on legal issues, a role that had been played by the Attorney General. It was not intended to, and it did not, diminish the Attorney General's preeminent role as the district's chief law officer, who, under Section 201 of the 2010 Charter Amendment, remains, quote, in charge of all law, business of the district, and all suits instituted by and against the government thereof, and shall possess all powers afforded the Attorney General by the common and statutory law of the district, and shall be responsible for upholding the public interest. A phrase I should note we've heard a lot about today. Rather, other than the agency general counsels, the 2013 Act left other OAG personnel and functions untouched. The Act specifically left within OAG the Legal Counsel Division and the real estate attorneys in the Commercial Division, both of which employ experienced attorneys who have traditionally worked in close consultation with other legal experts in the Office of the Attorney General and the agencies to furnish legal advice to the mayor, the deputy mayors, agencies, and the council. Nothing in the text or in the history of the 2013 legislation diminished the Attorney General's pre-existing and essential independent responsibility for, in the words of the charter, as amended by the voters, the, quote, charge and conduct of all law business of the district, unquote. The MOLC and other lawyers who report to the mayor or her designees may advise the mayor and agencies, but their legal positions are not controlling. If its legal views differ from the Attorney General's, the opinion of the Attorney General governs. As courts have recognized, opinions of the AG operate as the guiding statement of law in the district government. And as I testified in support of the 2013 bill, the MOLC would be responsible for implementing the Attorney General's legal views across the government. I noted in that testimony that under the bill, the Attorney General would remain, quote, the boss with respect to legal interpretations of statutes and regulations, and would continue to be, quote, responsible for the commercial activities of the district. A responsibility that cannot be meaningfully fulfilled unless the OAG advice-giving divisions are playing an active legal counseling role in the district's commercial real estate work. Moreover, an agency counsel could seek and receive opinions from the Attorney General if the General Counsel disagreed or was uncertain about the view of his or her agency director on a question of law. That was the fundamental premise of the proposal in the bill that was adopted in the 2013 law. At no point during that hearing, the committee's review of the legislation, or the council's first and second readings of the legislation, did any council member suggest that the MOLC would, to any degree, displace the Attorney General. And for good reason. Public integrity, clarity, and principles of checks and balances and effective governance of the district require that the district's key legal decisions and judgments be made by the Attorney General, the single voice for the city on any issue, absent a court decision to the contrary. The proposal by our current mayor to cut out the Office of the Attorney General from review of the major transactions entered into by the district would be both contrary to the 2013 bill and a step back for the district. Providing legal opinions is a critical function of the OAG, and this was both the understanding when the charter amendment passed to making the office elective and when the electorate voted for the current Attorney General, Carl Racine. The voters chose someone whose legal opinions they trusted. They had no role in selecting the MOLC, whom the statute suggested was going to ensure that all of the agency general counsels under the mayor followed the OAG's opinions. The mayor's proposal to change the rules and the roles after these elections is not faithful to the intent and understanding of the voters. I therefore urge the council to pass legislation that ensures that the OAG continues to play this critical advice-giving role to the district's economic development officials for the sake of the actual and perceived integrity of District of Columbia transactions and for the benefit of the public. Sincerely, Irvin Nathan.
Thank you for reading that letter into the record, Ms. Waldman, Ms. Levinson Waldman. We're going to move on next to Ms. Redmond.
Good afternoon, Mr. Chairman, and members of the Committee on the Judiciary. My name is Leona Redmond, and I'm a Ward 5 resident of the District of Columbia. I come before you today to urge you to enact in its entirety Bill 21-2 0139 into law as soon as legislatively possible. This bill, the Attorney General Independence and Authority Implementation Amendment Act of 2015, seeks to implement and execute what we, district residents, sought to obtain and got by way of referendum in November 2010. Even though the electorate spoke resoundingly throughout the city, I watched this council vote to delay, for no good reasons, the election of an attorney general, forcing a court challenge where the bad decision made here was overturned, and through our Circuit Court of Appeals, not our voices, we were able to elect our very first attorney general in November 2014, as we intended. Total separation of powers is imperative here. The legislative, executive, and office of the Attorney General branches of government have unique roles and responsibilities to society. The power inherent to each branch of government forces the checks and balances among the three branches that are necessary for good governance and forces the best possible outcomes for the public at large. Fortunately, the opportunity for the creation of a mayor's office of legal counsel died with the election of our attorney general. We chose by way of referendum to elect an attorney general so that we would have separate, equal, well-processed legal representations and renderings on matters of public policy before, during, and after laws are passed that regulate our city's business. Of the approximately 120,000 voters who chose to weigh in on Charter Amendment 4 during the 2010 general election, 75%, 90,000 voters chose to have an autonomous voice through an elected attorney general. Through our united voices and the language embodied within the referendum itself, the language we have said to you that the Attorney General is the District of Columbia's attorney at and on every level, and in my layman's opinion, there is no legal authority for a MOC in the office of the mayor. The Attorney General is the legal counsel for the District of Columbia, including the office of the mayor. This newly created MOC should not be funded by the council because it undermines the office of the Attorney General. Based upon my understandings of the budget justifications for the MOC, it strips the Attorney General of the powers and resources necessary for the Attorney General to carry out the responsibilities of the office. In fact, it appears to me, a layperson, that the office of mayor, by creating a MOC, has in fact submerged and silenced the Attorney General with the overshadow of its presence. What sense does this make? Hasn't it been proven throughout time that absolute power is not good in a democratic society? Once again, I urge you to support Bill 21-0139 in its entirety to the council for passage into law as soon as is legislatively possible. Thank you for this opportunity to give you my opinion on the merits of the Attorney General Independence and Authority Implementation Amendment Act of 2015. Since the council itself took no action to make the necessary amendments incidental to the creation of this separate but equal branch of District of Columbia government, I am truly pleased the Attorney General himself took this proactive step so that we will soon have 3 equal branches of district governance. Thank you.
Thank you, Ms. Redmond. Good to see you.
Good to see you too. Thank you.
Sir.
Thank you, Mr. Chair, and other distinguished members of the committee. My name is Delvon Michael. I'm the Executive Director of DC Working Families. We're a growing progressive organization launched by a grassroots coalition of local activists, community groups, and labor organizations dedicated to the premise that our children's life chances must not be determined by birth, and that local democracy must work for everyone, not just the wealthy and well-connected. My organization did not endorse Mr. Racine. I did not vote for Mr. Racine, but I'm here today in support of Mr. Racine. The district must have an independent Attorney General. The Attorney General currently carries out a number of roles which have a potential to create tension with each other. The Attorney General is a politician, a member of the government, but also acts as an independent legal advisor and guardian of the public interest. The test for any proposal for change should be whether it enhances the effective administration of justice, the maintenance of the rule of law, and the protection of the public interest, and enhances the public confidence in the office which they serve. In our opinion, the proposal does none of these things. Unlike the U.S. Attorney General, most state attorney generals are not part of a unified executive. Typically, they are neither subordinate to nor serve at the pleasure of the executive. Only some jurisdictions mandate that the Attorney General work in conjunction with the executive. 6 jurisdictions are a member of the cabinet, and only 3 of these are they appointed by the executive. In most jurisdictions, the Attorney General is independent, either because it is selected by the legislature, the state Supreme Court, or in most cases, and recently the District of Columbia, they are elected. Under the common law, English attorneys generals both serve the wishes of the crown and occupy a position of power and discretion. When the office was translated to the colonies, the diffusion of power throughout many agencies and heads of government necessitated a broader grant of discretion. Accordingly, the common law is a vital source of power for the Attorney General, who seeks to protect the public interest in developing areas of the law. The common law power to represent the public authorities, many attorneys generals, and to file suits on behalf of the people. Attorney generals have launched lawsuits because of tobacco companies, America Online, General Motors, Mazda, Sears, Robux, and others, and have therefore imposed state-based regulation with nationwide impact in consumer protection and environmental regulation and securities regulation. Attorneys generals have also invoked their common law authority to represent the public interest when filing lawsuits challenging the validity of state and local law. Focusing more locally, as you've heard the numbers, that district voters overwhelmingly chose an independent Attorney General. 76% of people voted to amend the charter. We wanted an Attorney General that shall have charge and conduct of all law business of the District of Columbia and shall be responsible for upholding the public interest. The council did a couple of years ago, they passed a law that transferred attorneys who serve as agency counsel for employment under the Office of the Attorney General to employment by the respective agencies. The current proposal simply runs counter to that and simply is just a bad idea. Ultimately, the proposal contradicts the law and undermines the public interest, and also it compromises the independence and objectivity of legal reviews on a host of matters, including real estate deals on property worth tens of millions of dollars, past controversies resulting in council-conducted investigations into executive practices, and recent perceptions regarding the cancellation of development projects serve as cautionary tales. Thank you.
Thank you for your testimony, Mr. Michael. I want to thank each of you for your testimony here this morning. I want to note that we've been joined by Ward 1 Councilmember Brianne Nadeau. Councilmember Nadeau, if you'd like to have any questions of this panel or take an opportunity for an open statement, you can do so now.
Thank you, Mr. Chairman. I'm just happy to be here with you. I have no questions for this panel, but I am grateful for this open discourse as we chart a new path of the district with an independent Attorney General. Thank you.
Mr. McDuffie, if I may,
Yes,
just
Ms. Redmond.
briefly. You asked some of my community friends when they were sitting up here a question that I would like to give my answer to.
Is that the question about that I asked, what they felt was meant by the charter amendment that said that the Attorney General shall be responsible for upholding the public interest and what they feel the public interest means? Is that the question or something different?
Okay, it was something different. You asked someone if the mayor wanted to institute a policy.
Yes, I asked a question about if the mayor had a policy or program that he or she wanted to implement, and the Attorney General felt that, for whatever reason, have a different opinion about whether or not it should be implemented. Should the Attorney General's authority be limited to the ability to offer legal advice and perhaps certifying any legal sufficiency, or did you feel as a person of the public who voted for an independent Attorney General that authority should go as far as to weigh in on policy or programmatic issues that the Attorney General had?
I think that's a great question, and you're gonna be surprised at my answer. I believe that if the mayor has if the mayor, whomever it may be, had a policy that it wanted to institute or a program that it wanted to create that was consistent with district law, that the Attorney General should not have the authority to say no to that, because I see the Attorney General as giving a legal opinion as to whether or not whatever the policy is, that is consistent with the law that's created here at the council. And so I wouldn't see the Attorney General's role to say whether or not a policy should be implemented if it's legal. I would see the Attorney General's role as determining whether or not the regulation that led to creating the policy was legal.
Okay, so I don't think
Does that make sense?
I think I understand what you're saying, and I'm not surprised by your response. I think most people who if posed that question, would probably respond similar to how you just responded. I just wanted to, with the previous panel, I was getting a sense that they felt like, well, I was concerned as whether or not they felt the Attorney General's authority extended beyond the realm of what's legal for that person, he or she being the chief legal officer, but not infringing on the mayor's authority as the chief executive of the government when it comes to policy and what direction the government should move toward. Okay. So no, I'm not surprised by your answer. I do appreciate you offering that. And I want to thank each of you for your testimony. Thank you.
Thank you, Chairman McDuffie.
And I'll just note that Mr. Nathan's full statement will be incorporated into the record.
Thank you.
That concludes the public witnesses that we had. I'm going to move next to our government witnesses. If we could have Ms. Beverly Perry, who's a special advisor to the mayor, as well as, I believe, Mark Toohey, director of the mayor's office of legal counsel, and whomever else is going to testify.
Ron Ross, the deputy director, will be at the table as well.
Yeah, I see. And Deputy Director of the Mayor's Office of Legal Counsel, Ron Ross. If you each could raise your right hands, please. Do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on the Judiciary is the truth, the whole truth, and nothing but the truth? Thank you very much.
Good morning, Chairman McDuffie.
Good morning.
And good morning, Councilmember Nadeau and staff. For the record, I'm Beverly Perry, Senior Advisor to Mayor Bowser. And with me is, as you just noted, Mark Toohey and Ron Ross, the Director and Deputy Director of the Mayor's Office of Legal Counsel. Thank you for convening this roundtable to discuss the recent proposals relating to the powers of the Office of the Attorney General and the Mayor's Office of Legal Counsel. Our testimony will address two legislative measures, Bills 21-139, introduced by Chairman Mendelson on March 16th at the request of the Attorney General, and Title I, Subtitle E, as included in the Budget Support Act of FY16, submitted to the Council more than 2 weeks later by Mayor Bowser. At its base, the two proposals represent fundamentally different perspectives about the role of the Office of the Attorney General vis-a-vis the executive, this council, and all of the other agencies and instrumentalities of the District of Columbia government. The mayor's proposal includes three simple provisions, beginning with a simple clarification that the mayor can seek legal advice from the lawyers assigned to her by law. The second provision would establish that the relationship between the mayor and the Attorney General is one of attorney-client. The third proposal would grant the Attorney General procurement and personnel authority to further the independence of that office. The Attorney General's proposal seeks to alter the relationship of the Attorney General to the executive and the legislative branches. It does so by reducing essential duties of those two branches and assigning them to the Office of the Attorney General. In effect, it creates a fourth branch of government with wide-ranging, unprecedented powers, which would substitute the judgment and the prerogative for those of the other branches. This proposal, if approved, would make the council and the executive dependent on the consent of the Attorney General. In fact, Attorney General Racine made this intention clear in his March 16th letter to this council, in which he wrote, and I quote, "Additional legislative authority changes are needed to allow the Office of the Attorney General to function co-equal with the council and the mayor," unquote. The Attorney General's proposal is a fundamental reordering of the district government that undermines the will of the voters, good government, and the duty of the legislative branch to check the executive. Before discussing the Attorney General's proposal more thoroughly, let me describe the mayor's vision for legal services in the District of Columbia. First and foremost, the will of the voters will be followed. That is why Mayor Bowser chose to implement Initiative 71, and it is why she's appealing the lower court's ruling on the budget autonomy case. The organizational chart that hangs in Mayor Bowser's office is a testament of her governing philosophy. The mayor, the council, and the attorney general report and are accountable to the people of the District of Columbia. Therefore, the elected attorney general should have the authority the voters sought to give the office. The core functions of the office of the attorney general did not change with the election. Those functions are representing the district government in affirmative and defensive litigation in the courts, issuing formal legal opinions on interpretations of district law, prosecuting criminal misdemeanors, and prosecuting and protecting the public interest in areas like consumer protections and the environment. The law already empowers the Attorney General to carry out those duties. The mayor has in no way interfered with the Attorney General's execution of the duties of his office. As Chief Executive Officer, Mayor Bowser is responsible for all operations of the district and executing its laws. In establishing the independent office of the Attorney General, the voters did not transfer to that office a host of duties properly executed by the mayor and the council. The voters did not cut back on the powers of the mayor. They did not cut back on the duties of the independent chief financial officer. They did not cut back on the duties of the inspector general, who is also independent, nor did they reduce the responsibilities of the Board of Ethics and Government Accountability, or critically, this council. There is only one chief executive, only one legislature, and only 3 branches of government. It is incumbent upon the mayor, the council, and the attorney general to work together in a spirit of goodwill and cooperation to identify a path forward that will best serve the expectations of the residents of the District of Columbia. How we proceed will set the stage for the relationship between the 2 branches of government and the office of the Attorney General for years to come. It is our sincere hope that today marks the beginning of a cooperative effort. With that said, today's discussion is vitally important. There are several provisions that, if approved, would harm the democratic organization of this government and thus merit discussion for the record. We urge the council to table the proposals in front of you and instead work with the executive and the office of the Attorney General to begin a dialogue about the future of legal services in the District of Columbia. I stated earlier that the Attorney General's proposal represents a reordering of the district government that would undermine the will of the voters, threaten the exercise of good government, and weaken our system of checks and balances. For instance, the Attorney General's bill mandates that that office shall have the exclusive charge of all law business in the district, including all of its offices, agencies, departments, and instrumentalities. This grant of exclusive power to the Attorney General does not reflect the council's need to have legal counsel to help it create policy, nor the need of the executive, or for that matter, DC Waters, DC Housing Authority, Events DC, to name a few, to be able to rely upon the advice of its counsel. Should the Attorney General have the immense power to substitute his judgment on all matters of law for the judgment of all other lawyers in the government? Should the Attorney General have the authority to tell the council's general counsel that her advice is unsound and thus cannot be relied upon? Or should the Attorney General have the authority to control the mayor's office of legal counsel, which was organized in large part to provide legal advice to the mayor, not by the mayor, but by this council it was established? As former Attorney General Irv Nathans noted in his 2013 testimony to this council on this issue, the mayor's office of legal counsel is needed to guard against political motivations of an elected attorney general. And since we just heard from a letter that Attorney General Nathans sent today, and it seems to be a change of heart, I just want to read from his statement in 2013. He said, "We should be prepared for some possible, sometime extreme conflicts between these two elected branches. The consequence of agency counsel being controlled by an elected attorney general's office, where the agency where they are charged with advising every day are controlled by the mayor, could, in some situations, undermine a conflict with the agenda of the mayor and agency directors. The mayor and the agency directors and program staffs depends on their agency counsels for legal advice and support, including transactional assistance and administrative litigation. Likewise, it could also adversely impact agencies' counsel ability to function effectively if they are expected to continue and to advise their agency directors from an elected attorney general's office. At the most extreme, professional ethics rules would preclude agency counsels from representing the mayor or agency directors and reporting to the attorney general when their interests are adverse." Those are Mr. Nathan's words in 2013. We heard different words today. This is not meant to impugn the integrity of the Attorney General. The law must not focus on one person, but instead should establish enduring principles that define the relationship between the branches of government and the person holding the office of the Attorney General. Also of concern is a proposal that the Attorney General's bill would give the office the exclusive authority to issue legal sufficiency certifications at any juncture in the legislative or policymaking process. Over the past few weeks, the term legal sufficiency has received a great deal of press. So what is legal sufficiency? It simply means when the mayor or the council proposes a law or a contract or a rulemaking, that lawyers for the mayor or the council review the measure to determine whether the proposed action is legally sound or whether any legal risk might arise from taking that proposed action. It is common sense and good business to understand the legal ramifications of a proposed course of action. And it is a function that has always been carried out by lawyers who report to the mayor and to the council respectively. Giving the Attorney General the exclusive authority to provide that legal advice overreaches and would amount to a mandate to seek the Attorney General's pre-approval before the mayor or the council could do their jobs. It would insert the Attorney General into the day-to-day business of the executive and legislative branches in an unprecedented and intrusive manner. For instance, imagine if you and your staff were required to consult with the Attorney General's office before submitting any legislative measure to the council. If a lawyer from the Attorney General's office sitting in on an early stage of policy discussion opposed the directions you were taking, would you, or the mayor for that matter, have to then alter course? The Attorney General has a significant role to play in the provision of legal advice when it is requested, and as a matter of practice, the advice is routinely sought. It is the reason Mayor Bowser invited Attorney General Racine to discuss the soccer stadium deal with her, and why her administration has continued to consult with the Attorney General on many matters. And it is important to note that even if the mayor did not seek the Attorney General's prior legal sufficiency review on a specific piece of legislation, regulation, or contract, the Attorney General would still be able to provide the legal review when the matter was submitted to the council or prior to publication in the Register. The Attorney General would still, if he chose, be an integral part to the legal review process, provide an independent legal review. But lawyers can disagree on matters of law and interpretation, and it is inappropriate to suggest that a duly elected council member or mayor is restricted to seeking legal advice only from the Attorney General. To suggest otherwise would amount to a broad grant of veto power over every branch and office of government. The independence of the office of the Attorney General is not questioned, nor has it been burdened. But it is entirely different. It is an entirely different matter to suggest, as the Attorney General has, that his is a co-equal branch of government to be consulted on all matters that the Attorney General determines of any legal consequences to the district. We also oppose the provision of the bill that would substantially broaden the subpoena powers of the Attorney General. This provision would permit the Attorney General to issue subpoenas for the production of any material or testimony relating to any matter. As it reads, it seems to be a blanket invitation for that office to intrude in the day-to-day business of government with no clear evidentiary standard and without any checks and balances. It is also unclear how this expansive subpoena power, which was rejected by the council previously, would not interfere with the investigative duties of the Office of the Inspector General and the Board of Ethics. A plain reading of the Attorney General's bill would also seem to impact the council's traditional oversight and investigatory role as it relates to the executive, a role it has faithfully and vigorously exercised. Notwithstanding the foregoing, there are several areas of agreement. For instance, the Office of the Attorney General should have independent procurement and personnel authority, as the mayor's BSA subtitle proposes. We also note the BSA subtitles clarifying the attorney-client relationship was worded in a way that could be interpreted as overly broad. Our intent was to clarify that the Attorney General carries out litigation in which the district government is a party in the same manner that an attorney carries out litigation for his client in the traditional sense. We believe this is a sound clarification to make. The Attorney General has authority to pursue litigation in the public interest on a range of matters without the consent of the mayor, although we believe that coordination between the Attorney General and the mayor is important and beneficial even in matters of public interest litigation. Let me emphasize that the day-to-day work of the Attorney General and his staff is excellent. We respect the experience, the judgment, and the competence of the attorneys and staff. We have experienced a collegial and collaborative relationship. However, we do firmly believe we must preserve the same independence and autonomy of the council, the executive, and the Attorney General. There is little surprise that the legislation establishing the elected Attorney General and the subsequent legislation setting forth the separation of legal services would eventually require further clarification. We look forward to the opportunity to work with you, your staff, and the Office of the Attorney General to advance these discussions. Thank you, Mr. Chairman, and for the opportunity to testify, and we will take questions from you, and our designated expert for questions is Mr. Ross.
Thank you. I appreciate it, Ms. Berry. And I do have some questions for you all. I just want to know if we could do 10-minute rounds. I imagine we're going to go longer than 1 minute. I do have a threshold question before we get into the nuts and bolts of what appears to be a dispute between what you all intend and the mayor intends with respect to the mayor's office of legal counsel and the attorney general with the bill that he sent down. And my threshold question has to do with whether or not subtitle E, Title I, that was sent down in the budget is actually germane to the budget. I want to know if you all had any thoughts on that.
The question being whether it's germane to the budget?
Yeah, I mean, whether or not it relates to budgetary issues in the sense that it deals more specifically with the mayor's office of legal counsel and not dealing with issues related to the budget.
Perhaps Beverly should address
Okay. We included in that was 30 positions for the Attorney General's office. I didn't mention that in my statement.
Okay.
And so, yes, we thought it was germane to the budget.
Okay.
Yes.
Okay. The other issue has to do with what I think is really the heart at what we're trying to clarify here, and it speaks to legal sufficiency. As you all know, legal sufficiency has been a practice conducted by the Attorney General for quite some time. It's not codified in the law. But it is something that the mayors in the past have relied on, particularly when formulating a budget. The budget was sent down to us, and there's been a question raised as to whether or not the subtitle, E, Title I, is legally sufficient. And if so, who actually determined whether or not it was legally sufficient?
I guess I'll speak to that. With respect, and maybe I should start out by saying this. I think one of the issues that's come up a great deal this morning has been a murkiness between three, I think, very different concepts that are all part of this discussion, and that is legal advice and who provides that for the council, for the mayor, for the agencies. Legal advice, legal opinions, and of course the legal sufficiency determinations. And I think there has been a tendency in a very public discussion to conflate those three issues. I think they are three very distinct issues, and I think we should keep them in mind as we go through some of these considerations. With respect to the sufficiency review of the Budget Support Amendment Act provisions that we're discussing this morning, as the council knows, you do have a determination, a rather lengthy determination that was provided by the Attorney General's office. That conclusion is that they believe that that provision is inconsistent with the charter on the basis of the analysis that they have provided. Our position here is that, in fact, what the mayor has proposed in our budget support amendment provision is consistent with the 2013 Act passed by the council, and that is what we are discussing here this morning.
Okay, and let me ask specifically about the provision that would, I think in the testimony of Ms. Perry, would clarify issues around the attorney-client relationship. Is it, in your opinion, does the language that seeks to clarify that relationship conflict with the charter amendment that outlines the authority of the Attorney General?
Yeah, I would like to take that one first because we have been discussing that, and this really affects a question that you have raised for various public witnesses, and that is this effort to define the public interest. If I am not mischaracterizing the position as I understand it of the Attorney General, the concern is that that language was inserted into the Mayor's BSA proposal in an effort to limit the jurisdiction, the powers of the Attorney General in the realm of the public interest practice that we've been discussing this morning. That was not the intention, and if you look carefully at that language, it actually does state that the relationship between the mayor and the Attorney General is that of attorney and client. Just so that we are clear, we were not suggesting that the mayor is the district, that the mayor is the district government, that when we are speaking of the public interest, that the mayor is the equivalent there. In fact, with respect to this area of the public interest that the Attorney General is empowered to pursue, and we've had discussions from various public witnesses as to what they think is embodied by that public interest. There is clearly a realm of law. You've seen it with respect to consumer advocacy actions. There's been some discussion earlier with respect to the tobacco litigation, areas where, as we know, across the United States, the state's attorneys generals have been very active in pursuing the public interest. In that realm, we were not suggesting that the mayor is, in that realm, the client, and thus the mayor would have the ability to direct the Attorney General with respect to those matters. In fact, I think, and I don't need to speak for Attorney General Racine, but I believe that he will tell you that with respect to that public interest practice, he is an attorney, and as an attorney, he has a client. And that client in that realm, I believe, it's the residents of the District of Columbia, it's the citizens, and the mayor's language with respect to clarifying that the relationship between the mayor and the Attorney General was not an effort to limit his powers with respect to the public interest. There are many aspects of the daily practice, and since I've been here, I have been practicing law in the weeds with the agencies, with the Office of the Attorney General, and on many occasions, we routinely seek the advice of the Attorney General's office, and we continue to seek it, and we will. And with respect to that advice rendering function, the Attorney General is acting as the attorney for the mayor. So there was no effort and no intention to limit powers with respect to his jurisdiction over pursuing the public interest. And so if that has been misunderstood, that was certainly not the intent. But I don't think that's a proper reading of that language.
Well, and I appreciate your clarification. I guess I would ask though, and I want to speak to what the language is, but if your intent was to clarify it, it could be an argument that it does, in fact, the opposite, because it would suggest that there was a need to clarify it. And so I guess I would ask, is there something that has happened that has prompted the executive to insert this language and to attempt to clarify the relationship? Or
Well-
what prompted the need to insert this
Well,
language?
well, as you know, the bill that was introduced, as well as when you hear the Attorney General speak, he says that he is the oversight over the mayor, the oversight over this council, that his bill would require the mayor not be able to even introduce a rule, a regulation, or anything without his pre-approval. And as you will recall, in his recent letter to the council, he said that, when he would approve, and he used the word approve actions, and the council he would substitute his role of checks for the council. And so in that language, we had hoped to say that the role of the Attorney General when he is working with the mayor is he's the attorney and the executive is the client.
So
Councilmember?
Please, Mr. Ross.
Could I just supplement?
Sure.
My response earlier, again, I'm sorry to drag everybody into the weeds, but there's a very practical application with respect to the settlement of various matters. And in fact, there is a proposal in the proposed legislation from the Attorney General's office that goes to settlement authority. There is a very strong feeling in the executive office of the mayor that ultimately settlements are coming out of funds that ultimately are under the control of the mayor. It is the mayor's budget. And so certainly, and this is part of the discussion that I think you want us to have in this forum. I think it's a vital consideration for the council in looking at settlement authority and this relationship of the mayor and the Attorney General's office, that the mayor has to have the ability to speak with respect to matters that ultimately implicate his or her budget.
My time has expired. I want to ask this final question for this round. In the attempt to clarify the relationship between the Attorney General and the mayor, the language that I read says, in all law business carried out by the Attorney General, the relationship between the district government, not the mayor, but the district government and the Attorney General shall be as client to attorney. Is that the operative language?
And I said in my statement that that was overly broad, and we think we want to clarify that.
Okay. Ms. Ross?
So if it is the district government, because that in the public interest litigation, of course, the district government, the Attorney General is representing the citizen.
Mm-hmm.
So I said that we wanted to clarify that.
Mm-hmm.
Yeah, I agree with that. But again, when we talk about the district government, again, take a concrete example. If a lawsuit is conducted against the Department of Health, we're not suggesting that the mayor is the district government. A suit filed against the Department of Health is a suit that would typically be filed against the mayor in her capacity as mayor. It would also be filed against the Department of Health and any number of agencies. With respect to that, as the language you read indicates, the role of the Attorney General is in fact to serve as the attorney for the district government. And the district government, in this case, that Department of Health, is in fact the client. So again, the amount of discussion of this clarification suggests that it may not be all that clear. But the one thing that we ought to be clear about is that that was not an effort to limit the powers of and the proper authority of the Office of the Attorney
So
General.
just to be clear, and I promise I'm going to Councilmember Nadeau after this. Just to be clear, is it the executive's position currently that the language in the subtitle that was sent down with respect to the malt runs counter to the charter amendment, or simply that it was broad and didn't properly convey what you were trying to accomplish?
Well, I think the the length of the discussion suggests that to the extent we were attempting to provide clarification, we have failed. But in direct answer to your question, no, we don't believe that that provision is contrary to the charter. Sorry.
And if you were to be able on the spot substitute language, would you just take out district government and insert mayor? Or how would you clarify then the language?
I bet.
And I'm not trying to hold you to this, and I don't mean to put you on the spot. I guess I'm just trying to better understand it.
No, I clearly, I wouldn't make that substitution because the mayor is not, you couldn't plug in the mayor for district government.
Right.
So that's not, to my mind, that's not the right fix.
All right, well, think about it, and my time has expired, so I'm going to come back on the second round and probably pick up where I'm leaving off
Thank you,
right now.
Mr. Chairman. I may pick up also, it may help a little bit. And I hate to try and out-lawyer all these lawyers here, but here we are. Perhaps I might suggest also language that explicitly says there is no intent to limit the powers of the public interest role that the Attorney General holds as well. But I thank you for acknowledging that the language itself has created some of this dialogue. That'd be a polite way of putting it. I wanted to continue to dig in a little bit here on the on Title I, Subtitle E of the Budget Support Act. Is there a fiscal impact that's been identified for these changes for Title I, Subtitle E?
Well, I think the fiscal impact would be, it is programmed into the budget, yes.
And has the mayor's office examined the fiscal impact of 21-139?
No.
No, okay. Well, I'm encouraged by the idea of tabling to create dialogue around this. It's clear that we need some more, and I would encourage collaboration on this point. Obviously, us all being here is an indicator that we would also like to collaborate. But perhaps Mr. Ross or Ms. Perry, you could walk me through which of the changes in Title I, Subtitle E are meant to be technical or clarifying, and which are intended as policy measures?
Well, I mean, you can go ahead if you'd like.
No, go ahead.
Yeah, I actually don't think we have any technical modifications in that provision. The effort was to keep that relatively narrow. I do understand the council has a fairly comprehensive proposal from the Office of the Attorney General, and perhaps I should note, if it isn't already altogether clear, the Attorney General has proposed to articulate more expansively the powers that he believes are incumbent from the referendum. The mayor's effort was to clarify a number of issues which, based on, frankly, based on the discussions around what is now the proposal from the Attorney General's office, issues that it was determined needed clarification. The mayor's office does not envision its proposal as an attempt to expand the powers of the office of the mayor, and certainly not the powers of my own office.
Okay, if I can take that one step further, Councilmember Nadeau, the mayor's position is that the election of the Attorney General didn't change. It changed the position from being appointed to elected. It didn't change the powers of the mayor. It didn't change the powers of the Attorney General. The Attorney General is assigned certain duties. The duties of public interest have always been with the Attorney General. The Attorney General has had suits, tobacco suits. We had this Standard & Poor's thing last year. I understand there was a used car dealers thing, action, public interest action brought by the Attorney General. All those powers have always been there. So the mayor's position is the election did not change the law. The mayor's powers or what they have always been.
Thank you, Ms. Perry. As a voter, that was also my interpretation of it. So I thank you for
Thank you.
clarifying that position. One of the concerns that I have here and always is duplication of services throughout the government. And so I will ask both panels a question about this, but could we walk through a little bit more what functions that the Mayor's Office of Legal Counsel and agency attorneys will fulfill that are necessary and different from the Office of the Attorney General?
Yeah, I'd like to defer to my director, and why don't I do that and then offer some comments? Sure.
Well, in effect, the legal business of the agencies of the district is carried on day in and day out by lawyers in those various agencies. From drafting contracts to drafting regulations to drafting legislation to advising the agencies, those lawyers carry that out. In the past, those lawyers reported to the Attorney General. With the 2013 Act creating the MOLC as the kind of supervisory type agency, these lawyers were transferred to the responsibility for them under the mayor. The MOLC's responsibility is to advise and guide, as we are able to on a day-to-day basis, those agencies. Issues come up that require some more in-depth analysis. To the extent that those issues are requests for legal opinions, that is the province of the Attorney General. Attorney General issues legal opinions, which are binding, unless the mayor and the council decide otherwise, but they're binding. And the Attorney General does that very well, day in and day out. Legal advice, however, is provided by the agency lawyers. And if particular expertise is required, the legal counsel division is consulted on a regular basis. But the legal advice is the province of the lawyers of the agency supervised by the MOLC.
So, okay.
Legal sufficiency, as my colleague said, is a separate entity. It is more akin to legal advice. It's not a legal opinion as such. It's legal advice about the transaction. In the past, legal sufficiency has been provided by the Attorney General's office as a subordinate entity to the mayor. And now in the transfer of agency matters, the mayor's position is that it's her decision and her discretion to seek legal sufficiency from the Attorney General on certain matters, legislation in the past, and even today, legislation and regulations has been utilized. But on other matters, mayoral appointments, mayor's orders, the mayor decides who she seeks that from. That does not diminish the power of the Attorney General to issue legal sufficiency on its own, and it in no way diminishes the legal counsel division's ability to assist the Attorney General in issuing legal opinions. It's actually a lot clearer than one would think.
Mr. Toohey, the way you describe it sounds a bit like the way we do it here on the council. When I think about when I'm consulting our general counsel day to day, which happens very regularly because we're looking at legislative intent, we're looking at all kinds of different measures that we want to get advice on, sometimes conflicts of interest, but we also call on the Attorney General for specific readings of the law.
Of course.
And how the government is implementing it, separate from the council or maybe more broadly. So in a way, it sounds as though it really is setting up sort of the same kind of independence that the council has had from the Attorney General. So that's interesting. I appreciate that perspective.
You can choose to seek the advice from your counsel. You can seek the advice of the Attorney General. The mayor has the same rights.
Very good. Thank you for that. I see I'm almost out of time, but if you could build on that for just a moment. How do you think expanding the OAG's role into more policy focus could in some ways prevent the mayor from executing her duties. Is his proposal going to sort of slow things down from a policy perspective? Would it create more conflict? Do you have a take on that?
Well, first and foremost, and I think Ms. Perry may have a comment, policy matters are the province of, I think, the mayor, and to some other extent, the council, policy matters. And I think that's where the primary responsibility lies. Legal advice on that comes from who the mayor chooses to consult, who the council chooses to consult. But policy advice is really a function of the mayor and to some extent the council.
Councilmember Nadeau, the advice from the legal review from the Attorney General occurs, on a bill. It occurs before the mayor signs it. The council passes the bill, and the Attorney General will certify that the bill is legally sufficient, and the mayor will sign it to make law. That happens on contracts, that happens on rules, it happens on many things. So with respect to policy, the question is whether or not the Attorney General's office has to be at the table during policy development, and then what stage do they have to be at the table? And the mayor's position is, I'm brainstorming about issues, the public, I go out to Ward 5 and they ask me to do something. So I have to decide and talk about when I do it. The question is, the Attorney General, as they say, they want to be on the table, at the table, ground floor. And we just see that as being, just overreaching. The Attorney General's office is not there for policy, they are there for law. I mean, the one thing I think we all agree to, that their job is law.
Very good. Thank you. Thank you, Mr. Chairman.
All right, and I a couple issues that I'm grappling with based on statements that you each made, and I'm gonna try to figure out how I'm gonna address them. But I feel like what you just said, Ms. Perry, is existing practice in terms of the Attorney General being at the table. So I'm sort of wondering how that would be changing anything, because I thought, and I'm not a part of the executive, but I thought that was already the practice that was in place in terms of the AG being at the table at a point fairly early, not necessarily on making policy decisions, but when it was time for the legal review to occur.
There are many times, for example, when I mentioned in my testimony, the mayor called the AG on the soccer stadium on what she was doing. Neither one had been sworn.
Mm-hmm.
I mean, this was in December. They weren't even in office yet.
Okay.
And so, but she was a council member, she was the head of, so she was legitimate there. He wasn't even a part of the government yet.
No, I understand.
And so she brought him in.
I want to get back to that point, because I don't want to lose my train of thought. I want to revisit what Mr. Ross and I were talking about earlier with the attorney-client relationship. And it still bothers me because I'm finding it difficult to find any legal basis to include that, to expressly include that in the code, because it seems to me it's a core function of the Attorney General to represent the public interest. And in fact, this committee's report accompanying the 2010 referendum stated that the Attorney General, and I'm quoting, must be able and in fact is required to say no to the executive when the law or ethics so require. So is it not inconsistent with the charter amendment to then say that we should outline this attorney-client relationship between the Attorney General and the mayor?
Again, I don't think so, and maybe two concrete examples. With respect to the response to the congressional inquiry with respect to the enactment of Initiative 71, which frankly is a good matter for us to discuss because it highlights an issue that shouldn't be lost today, and that is perhaps this morning, as evidence to the contrary, we are working on a daily basis in a very cooperative fashion. The mayor was sworn in on January 2nd, the Attorney General was, and we are getting the district's legal business done. But with respect to responding to the congressional inquiry on 71, our office worked collaboratively with the Office of the Attorney General. The Attorney General, in fact, directed the production of documents that were responsive. The Attorney General quite correctly asserted attorney-client privilege with respect to that production. There very clearly is a relationship of attorney and client between the Attorney General's office and the mayor's office, and frankly, and the agency. So
I guess I really can't figure out, I'm grappling with this, and I don't want to spend too much time on this. Why the need to actually include that then, if it already exists? And it's working, it seems, as it should. Why the need to include it?
Why do we need to include?
To spell out the attorney-client relationship that is included in the BSA title that you all sent down.
Because you had a proposal before you.
Okay.
in bill.
So that is anticipation of what was included in
Yes,
the Attorney
that
General's bill.
said, that said his powers were pre-approval powers, and that's not the powers of an attorney-client.
Okay, and I'll ask the Attorney General about that when we talk to him next. Let me move on to something else. In 2013, the council created the Mayor's Office of Legal Counsel through the Elected Attorney General Implementation and Legal Services Establishment Amendment Act. And the duties of the office, as we've already been talking about, are spelled out and are somewhat minimum. Number one, coordinating the hiring, compensation, training, and resolution of significant personnel-related issues for subordinate agency counsel in conjunction with agency directors. Number two, providing legal and policy advice to the mayor and the executive branch. Three, resolving interagency legal issues for the mayor. Four, overseeing the representation of agencies in investigative matters before the executive branch of the federal government, Congress, or the Council of the District of Columbia. And five, supervising outside counsel matters where the Office of the Attorney General is recused from a matter or otherwise not available. How do you all reconcile that, which is codified in the statute, with the desire to have the MALC perform exclusive or have exclusive conduct over legal sufficiency reviews upon request, but then also having the OAG perform the same function with respect to legal sufficiency reviews upon request?
Well, may I correct you respectfully, Mr. Chairman? There is nothing exclusive in the language on legal sufficiency. It is thought, and it's the mayor's position that as in the past, and as with the council as well, legal sufficiency, undefined as it is in the law, as you've indicated, and Mr. Cook also indicated that earlier, and it is not a requirement of law, it's a practice. And it is the mayor's position that it should be her decision to whom she seeks the request for legal sufficiency. It was meant in the provision, as I don't have it in front of me, but as I recall it, it says the mayor can seek that from the Attorney General or can seek it from the MALC. That was merely, I think, clarifying what the mayor's view is as we move forward in a bifurcated situation with an elected Attorney General and an elected Chief Executive.
Mr. Chairman, may I add one thing?
If I could, though, before Ms. Perry, I'm sorry. I want to ask a question of Mr. Tewitt. If the Mayor's Office of Legal Counsel issues or certifies something as legally sufficient, and the Attorney General's office certifies something as legally sufficient, but the two certifications differ, who's trumps?
I don't think there's an easy answer to that. If it was a legal opinion,
I'm talking about legal sufficiency.
I know you are. No, I know you are. You're talking about a different situation. Legal sufficiency where the MALC issues issues one view, and the Attorney General's because the Attorney General's office is entitled to a good bit of deference in general on legal issues. I think we have to look at it very carefully, and the mayor ultimately would have to make up her mind as to which she followed. I mean, that's true in any situation like that. That's true in the states where an attorney general and a governor's council disagree, it's got to be sorted out.
We actually have a live example that may be helpful, certainly as the council goes back and again considers these questions, and that is the ongoing litigation over budget autonomy. With respect to budget autonomy, the previous Attorney General and the current Attorney General both have very public positions that the Budget Autonomy Act is in fact invalid. Those are public positions. The current mayor has in fact taken a very public position that she disagrees. And how is that playing out? We have checks and balances to address what is clearly a conflict on a question of law. That matter is before the courts and will be decided by the courts, and it doesn't prevent the Attorney General, the Chief Financial Officer, or the mayor from continuing their respective duties. So that is how that tension plays out with respect to a good faith disagreement on a point of law.
Where do you all, in your opinion, where would you derive the power to issue legal sufficiency reviews? I'm looking at the statute that created the MOLC, and I see what it gives you authority to do. And, you know, for example, under B, providing legal and policy advice, I don't see legal sufficiency certifications anywhere. So where do you all think you derive that authority to do that?
Well, in fact, council member, as you have pointed out previously, if you look through the current code, you won't see legal sufficiency spoken of with respect to the Attorney General. It simply isn't there, and as Director Toohey addressed earlier, I'm sorry, actually, that came from Senior Advisor Perry. We sought to clarify this issue only because there is in fact legislation that seeks to address that.
So is your concern, I'm sorry, Ms. Perry, you want to make a point earlier?
Yeah, legal sufficiency, as I stated in my testimony, it is not something, we talk about it like it's something obscure. It is to advise the mayor. I mean, we get legal sufficiency on everything, a mayor's order, everything the mayor does. There's a memo that says it's legally sufficient. It is from the most minute thing to, you know, to large opinions that go to the Attorney General's office. So, and to, Mr. Chairman, when you talk about the conflict, it is very rare that there would be a conflict because the things that we get legal sufficiency from the MOLC, they don't go to the Attorney General's office. So the likelihood of a conflict is, you know, is very small. Because the things that we get legal sufficiency, the mayor is gonna, you know, the nomination process. The mayor is appointing somebody to serve on the taxicab commission. We get a legal sufficiency opinion on that. That's done by the MOLC. It doesn't go to the Attorney General. I mean, you know, some of it is very routine. And so when you talk about conflicts,
what about the things that are,
the likelihood of a conflict is just very small.
What about the things that are less routine? What about these complex land disposition deals that are happening in agencies? And I thought I understood Mr. Cook to say that legal sufficiency was something that, although not enumerated in the law, is something that he thinks falls under the Attorney General's authority by virtue of the Attorney General having authority over all law business.
Well, in the past, that is true, that the land disposition have been reviewed by the Office of the Attorney General as much as anything to properly structure the transaction. The deputy mayor for development decided, and he and I together informed the Attorney General that of his decision to appoint a general counsel and a deputy general counsel in his agency. And the two people that he chose for that position and made offers to are two of the finest lawyers in the city, in the district, who have been doing this work for years as assistant in the Office of Attorney General. And he offered them the new positions that were created. And what that does, that enhances the ability of the agency to make good decisions and to structure transactions in a way that are practically, business-wise, and legally in line with the district's priorities and in line with the law of the district. The Attorney General, to the extent the Attorney General wants to review those transactions, that power will never be taken away.
So
It
how do
just
you
enhances
reconcile-
the ability of the agency.
But how do you reconcile the letter provided by, submitted for the record by former Attorney General Irv Nathan, who was a proponent of creating the Mayor's Office of Legal Counsel for the reasons that Ms. Perry articulated and reasons that he testified to before the council? How do you reconcile what you just stated with the fact that he specifically said that the work being performed by attorneys in the commercial division should not be included in the transfer of authority over to the Mayor's Office of Legal Counsel by virtue of the general counsels and agency counsels?
Well, you know what, I think when he says the work being done by the commercial division being transferred, it's not going to be transferred. We are hiring some lawyers, and they will do the advisory work on transactions that a lawyer would do on transactions.
So there's a role of the Attorney General with respect to working through those complex deals throughout the process, still preserved in what you envision to be the future if this passes?
And the Attorney General will be brought in when those lawyers feel that it's appropriate to bring them in. And as I read to you from Mr. Nathan's statement back in 2013, he said in 2013, the mayor should have transactional lawyers. Today, we heard a statement, and you know, we all understand how, you know, opinions might change, but in 2013, he said the mayor should have transactional.
I don't make the case, and I don't know that Mr. Nathan, I don't want to speak from him, he wasn't here, so I couldn't ask him any questions, but I guess I am less concerned with the mayor's desire to hire whomever she thinks is necessary to implement her vision for the city, and she was elected to do that. She's the chief executive of the government. But I think what is less clear and is concerning for me is a desire and the appearance that in an attempt to hire very qualified lawyers to do some of the transactional work, you're cutting out a function of the Attorney General that has been performed for decades.
We're not.
I don't think that's true. I think that the structuring of the transaction with these lawyers on board will enhance the ability of the agency, and I think will enable the Attorney General to be very comfortable with the kind of legal work that's being done there. But the Attorney General maintains the ability to review it. Sure, he does.
So spell out for me why we're going in this direction then. Is there something that happened in the past? Obviously, we're in a new realm where we now have an elected Attorney General, we've got a mayor, and there's separation of powers issues. Obviously, I don't think anybody
It's a
wants...
bifurcated executive.
Right.
It's what it is.
I don't think anybody wants an elected Attorney General who is going to supplant his judgment for the judgment of the chief executive of the government. But at the same time, I think what we've heard from people who've testified, and it's been my understanding that we want an independently elected Attorney General who is going to conduct and have all the law business be in that AG's domain.
John, go ahead.
Actually, and that's helpful, and you mentioned, and I didn't get a chance to respond to this, you mentioned the testimony this morning from the former Corporation Counsel, Fred Cook, and he did make a statement that I think the council should consider, because he spoke with respect to what the council did in the 2013 statute that, yes, created the mold and also transferred those agency general counsel and their lawyers. These were attorneys. They were involved in the advice-giving function. They were employed by the Office of the Attorney General. Mr. Cook suggested, actually stated, that by virtue of the 2013 Act, which transferred them into a different reporting authority, that somehow they became incapable of rendering legal advice. I'd suggest to you there's nothing in that 2013 statute that suggested that there was any intent to change the function of those attorneys. And it frankly would beg the question, what these people who are in fact attorneys who a year ago were employed by the Office of the Attorney General, what are they doing in the agencies? It appears they are doing precisely what they were doing a year ago. And so to the extent that that is clearly part of the legal business of the District of Columbia, then clearly part of this discussion should be where that business is conducted. Those are clearly attorneys conducting legal business.
And I want to address that, but also I think what you just stated amplifies the concern that some have with the fact that you all are hiring a general counsel for DEMPHAD, where specifically the lawyers who did the work for DEMPHAD were not included in the transfer of attorneys. So why then create these attorneys in the Deputy Mayor for Planning and Economic Development in that agency where they weren't previously included in the transfer of attorneys who were performing certain duties before the law went into place?
Well, first of all, I understand that there are a host of reasons why the attorneys remained under the Attorney General during this period. But the decision was made by the executive to have this important agency have its own general counsel, as all the other agencies do. And those agencies depend on general counsel to provide legal advice, that's important legal advice, and that's what these two lawyers are going to be doing.
Is it, and clearly the statute that created the MOC speaks to providing legal and policy advice to the mayor.
Yes.
But is the legal and policy advice provided by the general counsels and agency counsels different, or is it the same as the legal advice provided by the attorneys in the Attorney General's office? Are you all equating the two?
What do you mean the same? I mean, legal advice is legal advice. I would think that once we get legal advice from the agency, unless we feel there is some, reason to go get a second opinion, and many times there are, and as you heard us say, routinely, I mean, every day, the lawyers of the MOC are working with the lawyers of the Attorney General. Legal advice, we can rely on the legal advice from the agency counsel.
Okay, so that would seem to suggest that the function of the attorneys and Attorney General would be irrelevant if you got your own legal attorneys to provide legal advice.
No, actually, I don't think it's irrelevant at all. And let's take again a daily example where I hope I can address what my office, what the agency lawyers are doing, as well as the Attorney General's office. This mayor is very committed to open government, as I believe the council is as well. And so one of the pressing matters of business is responding to FOIA requests. FOIA is a district statute. When we receive an inquiry, and by we, I mean one of the agencies receives a FOIA request, that requires that somebody make a determination as to what that agency is required to disclose. Judgments have to be made, some of them policy, as to what it would choose to disclose of that which it might otherwise exempt. Legal advice is provided every day on those questions by those agency general counsel and those agency lawyers working under those agency general counsel. Our office, which is attempting, among other things, to provide some general guidance for consistency's sake across the agencies, also stands charged to address appeals from those FOIA determinations. And we also turn to the Office of the Attorney General because in what hopefully will be the rare case where we actually end up with FOIA litigation, and there is some outstanding FOIA litigation, we in fact turn to the Office of the Attorney General. at all three levels, if that's three levels, the agency, council level, our office, the Office of the Attorney General, we all have a role to play. We're all playing those on a daily basis. There is no duplication. To address the concern of Councilmember Nadeau, there's a role to play, and there's no effort or intent to exclude any of those levels from playing their rightful role. I do think and hope the message doesn't get lost that this is a valuable discussion, but we can't lose the fact that the legal business of the district is in fact getting done, and I don't think with any great disruption we're getting this work done, and I don't think we should get lost in hypothetical concerns. The reality is that we are in fact working collaboratively.
I think that's a very important point, and the business is getting done, and perhaps we shouldn't get involved in hypotheticals, but here's the concern I have with that. If the business of the district is getting done as it currently stands, we're essentially debating proposals that would address hypotheticals. These proposals aren't designed to address necessarily any problems that currently exist. They're designed to address hypothetically if there's an overreach by the Attorney General. No?
No, that's exactly what it's designed. We're here today not because there is a problem. We're here today because the Attorney General is seeking to expand his powers. He's overreaching.
And there's a concern by the executive that he's overreaching.
Yes, there's a concern by the executive that he's overreaching. He's overreaching his powers, the powers of the office. As we all know, we've seen this government work for decades. The election did not change the powers of the office. The mayor's office is empowered to do the exact same thing today it was empowered to do last year.
And there is another point, Mr. Chairman, and that is that at the oversight hearing, we had a good discussion with you.
Sure.
And I think we all recognize that there was, in the Council's 2013 legislation, in the implementation of that, there were some nuances that needed to be clarified. One of those was the role of the Mayor's Office of Legal Counsel in having an assisted supervisory relationship over the agencies, which was intended when that was discussed. That was one of the reasons. It was really more of a clarification because of the nuances.
Let me ask this: is the mayor's office still currently, the executive, I should say, still consulting with the legal counsel division of the Attorney General's office on the development of legislation?
On a regular basis, we are. Yes.
Okay.
Yes.
Yes, absolutely.
Let's try one more time at a question that I feel like I didn't get a sufficient answer to earlier. I don't think it was because you didn't answer the question, but for me, as the chair of this committee, I think I would like to clarify. I asked if, under the mayor's proposal, there were legal sufficiency certifications provided upon request by the Mayor's Office of Legal Counsel, as well as the Office of the Attorney General, and they both issued legal sufficiency certifications which had different conclusions. Whose would trump?
And the answer to that is that would almost not occur because, I mean, for legal sufficiency on day-to-day operations, the kind of legal sufficiencies that the mayor's office provides, they wouldn't go to the Attorney General's office. So the likelihood of a conflict is just not there.
But in the event of a conflict, since it's the mayor's decision to seek legal sufficiency, it would be the mayor's decision
But the AG has the authority to render their own independently of whether or not the mayor requests it, no?
The Attorney General's office can choose to initiate its own legal sufficiency.
And so I'm talking
opinion.
about that
It can.
scenario.
Yeah, it can, without being requested to do
Sure.
so. I mean, I think it's a fair reality that if the mayor requests from A and B also, I mean, the chances of difference in that,
I don't think
are
that's
slim.
the scenario that's gonna happen. I'm talking about where the mayor requested from her Office of Legal Counsel and the Attorney General on its own issues a legal sufficiency.
That's what I'm referring to.
Okay, I'm sorry, go ahead.
In that situation, it seems to me it would be the mayor's decision on which of the opinions, which of the legal advice to accept. It's her decision. Mayor's the chief executive. There's only one chief executive, and it's her decision. Could this end up in court? I suppose it could, but it's really the mayor's decision.
Which precisely what I'm trying to avoid. I mean, we're talking about a situation where we've got, and look, I think most of the folks who followed this creation of this office closely anticipated there would be areas that needed to be clarified at some point. And I'm
Yes.
looking at Walter Smith as I'm saying this.
Mhm.
I don't think we foresaw everything that was going to happen, right? And so I think it's important to have this dialogue, and this has been incredibly helpful. But inevitably, if we go forward with the mayor's proposal, this will end up in court. I don't see how you avoid it, because you're saying that the mayor's office of legal counsel should be allowed to do something that has been done for decades by the office of the attorney general, where the attorney general has the authority to conduct the law business, all law business of the District of Columbia.
Well, as modified by this council in 2013, yes.
Yes.
Right.
Yes, but again, it's the mayor, you know, with legal sufficiency, because you have to be careful about hanging too much of a hat on this, it is not a requirement of law.
I understand that.
And so it is really the mayor's decision who to seek it from and how to accept it.
Okay. Would the mayor is the mayor authorized under the law currently, although it's not required or even expressed in the code about legal sufficiency, if the AG offers a legal sufficiency, or actually does not certify, offers an opinion that says that a bill proposed by the mayor is not legally sufficient, although the council passes it, and there's this AG opinion out there, can the mayor sign that?
The practice has been the mayor does not sign a bill. I mean, I think throughout government, from what we understand, but is it required by law? We don't see, we haven't found anything in the law to
So
support
the mayor
that.
is authorized under the current law to sign something, even though the attorney general has offered that it is legally insufficient?
She's not prescribed by law. That's the issue. She's not prescribed by law from doing it.
Okay, so she can sign it, essentially. I'm gonna
The
put it, I know
practice
we
has
got a lot of
been
people.
that she doesn't, and in fact, in the past and as recently as now, the AG's office reviews legislation. Yes, they do.
And Mr. Chairman, you asked another question.
That's likely to stay.
There's nothing in the code that authorizes the Attorney General to unilaterally offer an opinion. The Attorney General's authority for issuing legal opinions is at the request of the council
Sure.
or the request of the mayor. Now, the
Sure.
code is silent as to whether he can do that unilaterally or not.
Right.
So,
But with respect to is there anything that would preclude the attorney general from reviewing a bill proposed by the mayor that is currently under review by the council and offering insights on that?
And actually, that's a very good question. The reality is, and again, we're losing sight of the fact that it's not in the interest of the mayor to proceed with proposed regulations, with laws, with contractual arrangements, where there's any anticipation of a dispute with the attorney general. The reality is that would play out. It would play out in a forum. If a piece of legislation came before the council would certainly turn to the attorney general. The council may not find itself bound by the attorney general's determination. The council, in fact, has its own counsel, and I hate to bring up budget autonomy again, but we have that very recent example. It did not, in fact, involve an independent attorney general. So it's really it's the underlying principle that illustrates. There is always that possibility of a good faith dispute as to questions of law.
Let me ask just, and I'm wrapping up now because I want to move to the Attorney General, but in terms of these attorneys who have been commonly referred to as the DIMPED attorneys, these attorneys actually perform work. Do they perform work beyond the role of the things that occur in DIMPED? How many attorneys are we talking about, as a matter of fact?
I believe you're talking, I put them in boxes. I think it's fair to say you have 2 supervisors who are within the Office of the Attorney General. You have 4 DIMPED attorneys who are actually funded by the Executive Office of the Mayor. And then I believe there's a 5th attorney who, I'm not sure.
OAG.
I guess he is in the OAG, but his functions are, I think, exclusively on DIMPED matters. And I should clarify with respect to those 2 supervisors, one of them is in fact the chief of the commercial division. So we certainly
within the Office of the Attorney General.
Of the Attorney General. So we should not suggest that her work is exclusive to DIMPED.
Okay.
It is not.
So, but all 7 of the attorneys who you're referring to currently are under the personnel or with the Office of the Attorney General?
That's correct.
And there's no written,
The payment is different.
but the payment for 4 of them
Yeah.
is coming from the Deputy Mayor for Planning and Economic Development.
Yes. Right.
And this is under an agreement?
There's an MOU that was entered into between the Venti administration.
Is this MOU written or oral? Was this a written or oral MOU?
I don't think anybody can find it. We heard that it was written.
So it was a written, it was a written.
It's several
memorandum.
administrations.
Okay.
I can't
Ms.
answer
Ross?
that question.
Sure.
I guess
It's clearly oral, it may be written, we didn't,
Okay.
I don't know.
Mr. Ross?
I think we ought to beg the opportunity to get back to you on that
Okay.
question.
I appreciate it. Are there any other attorneys who are employed by the Office of the Attorney General but whom perform work under an MOU, either written or oral, for agencies in the executive? Are there any other similar situations?
Not that I'm aware of. And as a matter of fact, when we were discussing the real estate lawyers, as we refer to them, we discussed, all the agencies have agency lawyers and advice independent of an elected attorney general. And for DIMPED, we thought some of the most controversial issues the mayor deals with will be transactional. So she needs people that's accountable to her, that to advise her.
So these lawyers perform transactional work. Do they perform any work or offer any advice on policy or programs?
Well, policy, real estate transactions are policy related as well as
said are
transactional.
not?
Are.
Are.
I mean, when they're going into a transactional consideration, there are policy issues that are considered, but they're there to provide basically legal advice.
Yeah. Look, I think when we're talking about government lawyers, and I understand that there's great concern about these DIMPED attorneys, but if you take away the zeros, these are attorneys providing legal advice to an agency, just as the attorneys in the Department of Health or in any of the other departments are. They're providing legal advice. And in direct answer to your question, in the government context, there is clearly a mixture of policy in law, in what an attorney is called upon to provide at a table.
And I'm trying to see if we can, and I know it's difficult, but how do you sort of distinguish between that policy advice and the actual advice which I think might fall under the realm of law business?
Instead of focusing on law business, I think what's paramount is the mayor is the chief executive officer of the city, and she is responsible for all operations and executing all laws of the city. There is no reason for the mayor not to have her counsel for that area as opposed to any other area. as Chief Executive Officer of the city to execute her duties in that area, she is entitled.
So what then do the attorneys in the Office of Attorney General do who weren't transferred over to the Mayor's Office of Legal Counsel? What do you, I mean, are you all suggesting that the authority of the Attorney General and the attorneys who rest in that office are simply to initiate or defend lawsuits and litigation?
May I correct one statement? There have been no transfer. These two supervisors were offered
I'm talking about
positions.
generally, the ones who came over from OAG to the
talking
Mayor's
about in
Office
the
of Legal
mold?
Counsel. I'm talking about generally, not just the DEMP head attorneys. I'm talking about
Just the
generally,
agency lawyers.
when we went from to
Okay.
created the office, I was talking about those attorneys who were transferred there.
To the agency. They came over under the
Right.
supervision of the directors of the
Well,
agency.
Mr. Chairman.
But there's
if-
some
if-
attorneys who
if
weren't
you-
transferred. So what do they do then?
There,
There are almost none.
as I said in my statement, the functions of the Attorney General's office are representing the district government in affirmative and defensive litigation in court,
Okay.
issuing formal legal opinions and interpretations of district law, prosecuting criminal misdemeanors, and protecting the public interest in areas like consumer protection and environment. And to answer your question, yes, most of that is embodied in litigation.
Okay.
And as the statement says, those are core functions, but we certainly are not meaning to suggest that our office, that the executive office of the mayor, that the agencies do not on a routine basis turn to the office of the Attorney General for routine legal advice, not legal opinions, routine legal advice and guidance. We do it every day. So we don't mean to disparage the role of the Office of the Attorney General. It is an expansive role. There is tremendous capacity. And the mayor, the agencies rely on those on a daily basis and will continue to do so.
Let me just give an example of a land disposition, some agreement that comes out of DEMP that's put together that's about to come to the council. The mayor's office has worked on this with the Mayor's Office of Legal Counsel, providing legal advice. It is, you include at some point after the agreement is reached, the Office of the Attorney General to do a legal sufficiency review and to certify this. The Office of the OAG says, you know what, we can't certify this. The mayor sends it down to the council anyway. I don't want to suggest that this is something that would happen frequently, but it seems to be something that could happen under the scenario that you all are suggesting we implement in terms of the MALC being able to have legal sufficiency review authority.
You know what, Mr. Chairman? I think that would never happen under this mayor. This mayor is.
And it might not, but what we're doing here are laws that extend beyond this mayor and this attorney general and this council member.
Exactly.
So I am concerned about the council, and quite frankly, the business of the District of Columbia and the work of the District of Columbia grinding to a halt if we have to deal with the scenario that I've just described, where attorneys on one hand are saying, this is legally sufficient, and attorneys in the Attorney General's office are saying it is not legally sufficient.
The reason, and you're talking about real estate transactions in specific when you say that.
Yeah, as an example, yeah.
Well, I agree with Ms. Perry. With the caliber of these two, these are two of the best lawyers in the city that have done this for years. It's not going to happen.
But you're talking about two people. These two people might be around for a year. They might be around for 6 months. They might not be around at all.
But as
ultimately.
Mr. Ross has said, it could happen not on just real estate, it could happen on any issue. Budget autonomy, it happened. The general counsel of the council said this is legally sufficient. The Attorney General's office said it's not.
Right.
And the council moved forward. So, I mean.
So you want the mayor to be able to move forward.
The mayor should be
irrespective of what the Attorney General says is legally sufficient.
I mean, it's a risk. The council can do it. right now, under the Attorney General's bill, neither the council nor the mayor would be able to do it. But as the law stands right now, the council could do it. The council is independent. The mayor is independent. And so, you know, and all we're asking you, preserve the autonomy that each of us has.
Okay.
The autonomy the council has, the autonomy the mayor has. The mayor has his general counsel. The council has its general counsel. And you have proven over the past year that you can select to go with your general counsel's advice. And you did.
There's another aspect. You have final approval. If you have a hesitation about a real estate transaction, you're not going to approve it.
You know, I understand that. I guess I'm more concerned about what Mr. Cook said when he said that he is, you know, doing things in the business community outside of government. He's going to go to the people who ultimately have the authority to approve something or give the final legal say on something.
So he wants to go to the Attorney General?
Well, it would seem that that's what voters voted for. I mean, they voted for somebody to be independent.
For land transactions?
Well, no, to have authority over the law business.
Okay.
To have authority over law business.
Yeah, with all due respect to Fred Cook, and I do mean that. I'm a project finance attorney. I know a thing or two about sophisticated transactions as well. To the extent that a transaction requires a third-party legal opinion, which I don't think anybody's suggesting an opinion from the Attorney General is or is being sought in any of these transactions.
Right.
That's a very different matter. The reality is when two sophisticated or however many sophisticated commercial parties show up for a transaction, they're responsible for making their own determinations as to the legal sufficiency of the commitments that they are undertaking, their ability to perform them. So I did find that statement to be an overstatement of commercial reality.
So does that eliminate the need under your scenario if you've got these really smart, sophisticated, experienced attorneys in the mayor's office, legal counsel, sitting down at the table with these development attorneys? Does that eliminate the need to even send something that DEMPE wants to do to the Attorney General's office?
No.
During that deliberative stage, yes, it eliminates that need during that deliberative stage.
Well, even after the deliberative stage, why
No,
bring
because it's
it?
going to come to the council. It's going to go to the Attorney General's
Why?
office.
But why? It's not required, right?
But the practice is not going to change. So we haven't had, it's never been required, but it always did come to the council, and the council always sought the
But
Attorney General's
you all are
approval.
specifically asking for authority that you currently don't have. And I'm just trying to reconcile, and
No,
look, and trust me, I'm just trying, I mean, look, we have one council member here, and then ultimately we may have 13 voting on this, so I'm trying to create a record that is clear for whomever wants to see what we're talking about and understand what we're talking about. The practice exists now, but you're asking for authority that you currently don't have, which implies that you want the practice to change and be different. And I'm trying to.
I'm sorry, Mr. Chairman, we are not asking for any additional authority. Our position is the mayor is empowered by the charter. Her power has not changed. The election did not change the mayor's powers. The practice that has always been adhered to, all we're doing is just articulating that there is a practice and it's always been adhered to.
So it's the mayor's
Attorney
position.
General's asking for a change.
So the mayor's position, and we're going to get to his bill as well, because it is, as you mentioned, is a pretty expansive bill. But is it the mayor's position that that attorneys for the executive already conduct legal sufficiency reviews?
Yes. There are some legal sufficiency reviews that are conducted by attorneys for the executive,
Okay,
yes.
so it's the mayor's position that you're not doing anything, you don't change anything, you're essentially trying to codify the status quo where the attorneys in the mayor's office of legal counsel, which is a new office, conducts legal sufficiency reviews as well as the attorneys for the in the office of the Attorney General.
Yes. And the mayor, all the bill is clarifying, it's not anything new, as Perry said, it's simply stating, as a fact, the mayor has the authority to decide who to seek this legal sufficiency review from. And in fact, in a number of situations, because if it comes through us, we consult with the Legal Counsel Division on a regular basis. But it's clarifying the fact that the mayor has the authority, and in fact, both entities have the ability and practice to, for legal sufficiency reviews. Yes, that's what it's saying.
Mr. Chairman, let me give you a Fred Cook analogy. He said that the city is a municipal corporation and the Attorney General is the lawyers for the corporation. I have a little bit experience in a corporation and working with the general counsel of a corporation. The CEO, the mayor would be the CEO of the corporation. The CEO is not required to go to the general counsel unless the CEO decides to go there. The CEO often can bring in an outside counsel. I'm not suggesting that in this situation, but I'm just saying there are choices. The CEO of the corporation has a choice to whom they seek legal advice from.
Mm-hmm. But and I'm gonna move on.
And the choices here were set up by this council.
But what you're suggesting is that the mayor seek legal advice from the mayor's office of legal counsel, whom are appointed by the mayor, that he or she would seek legal advice on complex land transaction deals that would bind the District of Columbia in an almost irreversible way, as opposed to getting it certified for legal sufficiency from an independently elected Attorney General.
That's not what we said. We said she would seek legal advice.
From
The
whoever
Attorney
she-
General would get, the Attorney General would be brought into the deal.
But the mayor, this would give the mayor authority. What you're suggesting in this BSA, this subtitle would give the mayor the authority to seek the legal advice from whomever she wants to, legal sufficiency certifications from whomever she chooses, either her mayor's office of legal counsel or upon her request, the office of the Attorney General.
But remember, you are the check on that transaction. The council is the check on that transaction.
Trust me,
And
I'm fully aware of
sure-
our role in this, but I'm trying to make sure
I'm
that.
sure that you would require that the Attorney General's opinion on legal sufficiency before any complex transaction. And that's what we're saying. It's not a matter of whether or not the Attorney General will be involved. It is a matter of what stage of involvement. That's all it is.
No, and I understand it, but my concern is if the AG isn't brought into the discussion about what's legally sufficient until the end of the deal, it slows down things. I imagine, you know, Mr. Ross, as somebody who works in this, it would probably slow down the deal to have the AG's office reviewing it after it's structured as opposed to during the time when it's being structured. I imagine that folks in the development community would be extremely concerned about that because they've got finance and other things that are at play here. And then you get the opinion, well, I don't want to use that word, you get the certification of the Attorney General, who is ultimately the chief legal officer after the fact. And so the advice that the Attorney General's attorneys would give after the fact might be different if they were sitting at the table when the time is being structured, no?
It would be foolish for the mayor to go through a proceeding thinking that that could happen. That would be foolish. She would never do that.
Okay.
She would want to make sure that people necessarily to be part of the transaction. As I told you, Mr. Racine wasn't even a government employee when she brought him
No, I
to the
understand
table
that.
on the soccer
I understand
deal.
that. I understand that. And look, I purposely avoided using, you know, Madam Mayor Bowser or Mr. Racine because I'm thinking beyond these two elected officials. I'm thinking about what we're putting in place and the fact that it will probably survive in terms of our elected terms of office, the folks who are making these decisions right now. So
Well,
that's my
it's
concern.
unrealistic to assume that people who've been involved in this business for years, from a supervisory standpoint and a legal sufficiency standpoint, are not going to consult with the office from which they left as the transaction's being developed. It's unrealistic to assume that.
That's one way to look at it.
That's why they're there. They're there to enhance the ability of this agency to have the same capacity as other agencies to structure transactions.
But why then create a legal obstacle that could cut them out? Why then suggest that the mayor should be able to go to this person and not these people? Why not leave it the way it is? Why not maintain the status quo? You know, I think what you said, and I meant to mention this earlier, Ms. Prayer. I think what you said to me really captures what we need to do. And I'm trying to find it you urged the council to table the proposals in front of you and instead work with the executive and the Office of the Attorney General to begin a dialogue about the future of legal services in the District of Columbia. I would submit to you that the dialogue began a while ago. And I would submit to you that I think there are things that I have deep concerns about in the mayor's proposal, and there are things that I have deep concerns about with the Attorney General's proposal. I would love that the dialogue between the two offices happen in a more meaningful and substantive way, because ultimately, I would like to avoid, as a council member, and I imagine my colleagues might, some public display in a lawsuit where 75% of the public said they wanted an independent elected attorney general, but yet you have a mayor who was overwhelmingly elected as well. And I think you both have the right spirit at heart. I just think that, if we could be a little bit more open, perhaps, in this dialogue, and open to compromise, we might be able to work something out. And I'm more than willing to try to weigh in if necessary. But my hope is that we can avoid this short, because I think both proposals are flawed.
We have no disagreement with what you just said.
Okay, all right.
And,
Well,
and we've been saying it.
Okay, well, I appreciate you all testifying here. This has been very helpful. Thank you so much.
Thank you.
If we could have the Attorney General, Carl Racine, and whomever else is going to testify on behalf of the Office of the Attorney General, please come forward. And before you're seated, if you don't mind, if you all could raise your right hands before you're seated. And do you each swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on the Judiciary is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Good afternoon to each of you. Mr. Racine, you can begin your testimony whenever you're ready.
Sure. Good afternoon, Councilman, Mr. Chairman, Mr. McDuffie. Good afternoon, my councilwoman from Ward 1, Ms. Nadeau, and good afternoon, staff who've worked so hard on these issues. Let me just say at the outset that the Office of the Attorney General appreciates all of the thoughtful, hard work. The Office of Attorney General also appreciates reasonable and respectful disagreements in policy and certainly in law. And we look forward to continue to work with your office as well as the executive and trying as best we can to reach reasonable accommodations that achieve the people's objectives. And those objectives were clear: an independent attorney general that would serve as a check and balance on government, not intruding in any way on the policy prerogatives of the mayor. Now I'll go to my prepared testimony. Good afternoon, Chairman McDuffie, council members, staff, and members of the public. My name is Carl Racine, and I'm the Attorney General for the District of Columbia. And on behalf of my colleagues at the OAG, many of whom are here, I very much appreciate the opportunity to be before you today. As you know, by an overwhelming 76% of the vote, citizens of the district passed a referendum in 2010 to establish an independent Office of Attorney General that would operate independently of the mayor and the council. In passing this mandate, the district joined 43 other jurisdictions, including Maryland and Virginia, that have elected attorney general who are directly accountable to the voters. Like Maryland and Virginia and the other 41 states that have elected attorney general, the AG has an obligation to act in the public interest and functions as a check and balance in government. These principles are central to a mature democracy and are a further step toward the district achieving full self-governance and statehood. The referendum contained numerous important duties and responsibilities for the elected Attorney General, including that the elected Attorney General have charge and conduct of all law business of the district and all suits instituted by and against the district government, the power to control all litigation and appeals, and the power and responsibility to act in the public interest. In anticipation of the district's first Attorney General election, the executive branch and the council evaluated and held hearings on how best to transfer from the unitary model
with an AG subordinate to the mayor to a bifurcated model seen in 43 states, where the sovereign's chief executive officer and chief legal officer do not report to the other. After extensive debate and hearings, the council passed the Elected Attorney General Implementation Amendment Act of 2013. Among other things, this act transferred supervision of agency counsel from the Attorney General to subordinate agency heads so that they would be within the mayoral reporting line and not that of the elected Attorney General. The act also included a provision creating the Mayor's Office of Legal Counsel, the MOLC, a small office that was headed by a director who was appointed by and to be served at the pleasure of the mayor. The unelected director of the MOLC was not created nor authorized to displace or diminish the role or responsibilities of the Attorney General. Unlike the former appointed Attorney General or Corporation Counsel, the director of the MOLC is not publicly vetted or confirmed by the council, required to have a minimum number of years of practicing law, or even be a member of the District of Columbia Bar. The MOLC is required to enforce the law as declared by the Attorney General. The opinions of the Attorney General operate as the guiding statement of law in the district government. Since taking office on January 2nd, 2015, as Attorney General, we've worked within the structure created by the council. Significantly, while I believe the council erred in moving lawyers out of OAG and into the agencies, OAG's budget support legislation does not seek an immediate return of those lawyers to OAG. Rather, I'm committed to working within the system that the council created. My testimony today will focus on the Mayor's Budget Support Act legislation, report on the removal of a particular group of OAG's real estate and commercial lawyers away from OAG and to the Deputy Mayor's Office for Economic Development, and lastly, touch on my proposed technical and non-technical clarifications, which I want to underscore, and the record will reflect, have nothing to do with a power grab, have nothing to do with encroaching on the mayor's authority for policy. Let me first focus on the Mayor's Budget Support Act legislation. We'll call that Subtitle E. Just over a month ago, the Executive Office of the Mayor provided OAG with the draft version of the Budget Support Act for legal review. As in prior years, OAG performed significant review and worked with the executive to prepare the draft Budget Support Act. At the end of this process, OAG certified the legal sufficiency of a version of the Budget Support Act that executive staff presented to us as final. The version of the Budget Support Act that the mayor actually introduced, however, included Subtitle E concerning the OAG, which my office, and has been publicly reported, was not given an opportunity to evaluate. This broke over 50 years of precedent. There's no one in the OAG who's ever been at the OAG who ever remembers such a thing occurring. The version of the Budget Support Act submitted to the council, which includes Subtitle E, is not legally sufficient because the subtitle itself is not legally sufficient. The subtitle would substantially undermine the independent role of the elected Attorney General that the voters incorporated by referendum into the District of Columbia Home Rule Act approved December 24th, 1973, and would accordingly violate the district's charter. The following analysis reflects the legal basis for this conclusion. On March 30, 2010, the council enacted the District of Columbia Clarification and Elected Term Amendment Act of 2010. That's the referendum. The purpose of the legislation was to make clear in law what is axiomatic, that the responsibility of the Attorney General is to serve the citizens of the district. Attorney General for the District of Columbia Clarification Elected a Term Amendment Act of 2009. The first two sentences of the committee report state, the position of Attorney General holds an elevated place in our democratic form of government as it is the public official at all levels responsible for justice. The Attorney General serves not only as a counselor to the government, but as an advocate of the public interest. The Referendum Act was designed to codify the institutional independence of the Attorney General and strengthen the Attorney General's role. The Council chose to accomplish these objectives by initiating the process of making the Attorney General an elective office and by establishing through the language and legislative history of the Referendum Act that the district's elected Attorney General would continue to perform the core functions of the office and serve as the lawyer for the citizens of the District of Columbia. The best evidence of the council's intent concerning the role of the elected Attorney General is contained in Section 101 of the referendum. That section states as follows: the Attorney General for the District of Columbia shall have charge and conduct of all law business of the said district and all suits instituted by and against the government thereof, and shall possess all powers afforded the Attorney General by the common law and statutory law of the district, and shall be responsible for upholding the public interest. The Attorney General shall have the power to control litigation and appeals, as well as the power to intervene in legal proceedings on behalf of the public interest. These sections could not be more clear in legislatively establishing the Attorney General's authority and independence. It states that the Attorney General shall be in charge of and conduct and control all of the district's law business and shall act in the public interest. It also restates the Attorney General's core functions as they have developed in the district, and along with other sections of the Referendum Act, affirmatively establishes that the performance of these functions shall no longer be under the mayor's direction or control. Excuse me. Thank you. In addition to explicitly stating that the Attorney General serves the public and is in charge of all the district's legal matters, Section 101 of the Referendum Act incorporates the core powers of the Attorney General as they've been described in other sources. The section brings forward the Attorney General's authority as stated in Reorganization Order Number 50, dated June 26, 1953, as amended, by referring to the Attorney General's opinion and advice-giving function included in that order and using language similar to that contained in the order describing the Attorney General's authority. All of this emphasizes, once again, the Attorney General's central role as being responsible for the conduct of all legal business in the District of Columbia. In addition, the section statements in subsections A1 and B that the Attorney General shall possess all of the Attorney General's powers under common law are very important. During its consideration of the Referendum Act, the Council accepted the conclusion advanced by D.C. Appleseed that the District Attorney General has common law powers that derive from the common law powers of this official in Maryland in 1801, when the land comprising the district was ceded. The role of the Attorney General has evolved from merely representation of a monarch to representation of an entire government and, importantly, its citizenry. Although the district's approval of the Referendum Act made significant changes to local law, the Council could not, on its own, convert the existing office of Attorney General into an elected office. The Council therefore included a proposed charter amendment in the Referendum Act, which Congress declined to affirmatively approve. The charter amendment, including the entire Referendum Act, was then submitted to district voters for approval during a referendum conducted on November 2nd, 2010. And indeed, the many public citizens who testified today underscored the overwhelming 76% vote in favor of an independent Attorney General. I'm going to talk a bit about the Independent Attorney General Act of 2013. In 2013, after the voters approved the charter amendment, the Council considered the Elected Attorney General Implementation Act. The mayor proposed this legislation after then Attorney General Irv Nathan advised that changes to the reporting lines of counsel in the subordinate agencies were necessary to ensure that the legal advice provided to these agencies reflected the agenda, policies, and priorities of the mayor. As a result, when enacted, the 2013 Act transferred the supervision and control of subordinate agency counsel from the Attorney General to the agency directors. The 2013 Act also created the Mayor's Office of Legal Counsel, the MOLC, a small office that would report to the mayor and be responsible for cross-agency legal training and other issues associated with agency counsel offices. The limited role that the 2013 Act assigned to the MOLC is expressed in the Act itself and its legislative history. Section 101A of the 2013 Act states that the MOLC's responsibilities are as follows: coordinating the hiring, compensation, training, and resolution of significant personnel-related issues for subordinate agency counsel in conjunction with agency directors, providing legal and policy advice to the mayor and executive branch, resolving intra-agency legal issues for the mayor, overseeing the representation of agencies in the investigative matters before the executive branch of the federal government, Congress, or the Council of the District of Columbia, and supervising outside counsels in matters where the Office of Attorney General is recused from a matter or otherwise not available. These functions replace the predominantly administrative functions that OAG performed before the 2013 Act in coordinating the activities of multiple agency counsel offices with disparate needs located throughout the district. The MOLC was envisioned as having only 5 employees, a director, 3 attorneys, and 1 administrative assistant. Its role, as reflected in its functions, is to ensure consistency in the duties, activities, and treatment of agency counsel who would be accountable to different agency directors, many of whom would be non-lawyers with different constituents and missions. As former Attorney General Nathan explained at a hearing on the 2013 Act, the MOLC provision of the mayor's bills were designed to implement the transfer of general counsels to the mayor. Some feared that placing agency counsel under their agency heads' supervision might leave agency counsel at the mercy of agency directors who want legal opinions that are not shared by the Attorney General's office. The MOLC would protect agency counsel from potential undue influence from their agency directors and would harmonize agency counsel's positions and decisions on substantive and legal personnel matters. Rather than diminishing the role of the Attorney General, the MOLC would be responsible for implementing the Attorney General's legal views across the government. The Attorney General would remain in charge of interpreting statutes and regulations and would continue to be responsible for the commercial activities of the district. Moreover, despite the creation of the MOLC, it was anticipated that an agency general counsel could seek and receive opinions from the Attorney General if the attorney disagreed with his or her agency director on a question of law. The MOLC's functions, as defined in the 2013 Act, were thus targeted to address specific concerns associated with the transfer of agency counsel back to the subordinate agencies. This entire endeavor was part of the district's overall effort to implement the Referendum Act and create a strong, independent, elected Attorney General. Let me draw your attention now to Subtitle E, that is the mayor's proposal as reflected in her Budget Support Act. The mayor's proposed changes to the Attorney General's powers and responsibilities are contained in Subtitle E of the BSA. That section would revise the Referendum Act and the 2013 Act in several ways that would conflict with the underlying policies of these acts, undermine the authority and the independence of the Attorney General, and unnecessarily expand the role of the MOLC and insulate the actions of the executive from independent legal scrutiny. Please direct your attention to subsection E's preamble. The preamble to the subtitle recognizes that based on principles of democracy, including shared responsibility, accountability, and checks and balances in the exercise of power, the subtitle would clarify the relationship of the Attorney General and Mayor to be that of attorney-client. Interestingly, the subtitle would purport to eliminate the Attorney General's authority to act independently to uphold the public interest and serve as the attorney for the district residents. I'm heartened at the conversation earlier today with Mr. Toohey, Mr. Ross, and Ms. Perry, who appear to be saying that the limitation language, speaking of an attorney-client privilege between the Attorney General and Mayor, had no intent whatsoever to encroach on the Attorney General's solemn obligation to follow the public interest. I'm heartened by that public representation. By purporting to restrict the Attorney General's role to acting as the attorney for the mayor, as the language and their draft bills suggest, what that would do is that would significantly reduce the elected Attorney General's independence. It's well known that under the rules of professional conduct and responsibility, a lawyer owes an obligation to follow the instructions of a client. What we fear is that the way that the mayor's proposal is drafted is that it would essentially leave the elected attorney general's office as being subordinate to the mayor. In short, she can get us involved when she wants, tell us what she wants us to do, and tell us not to do certain things as an attorney-client privilege in a normal course would have. Clearly, with the Attorney General, an elected Attorney General, the responsibility goes far beyond just defending and representing the mayor and the district. There's an independent line of representation and duty to the public interest. The omission of what the voters and the council made clear in the referendum in 2013 would call into question the Attorney General's ability to bring actions on behalf of the public interest or representing the interest of district residents, independent of the mayor, as the Referendum Act intended. This portion of the Referendum Act, this portion of the proposal would thus negate one of the primary purposes for which the referendum was enacted. To be clear, there's no question that the independent elected Attorney General is charged with and does represent the mayor and the district government in the majority of their activities and operations. The Attorney General has historically provided legal advice to the mayor, the council, the courts, and the subordinate agencies, and the Attorney General has had the responsibility to speak for the district on legal matters as part of the Attorney General's core functions. In addition, the Attorney General has provided important legal assistance to the mayor and the subordinate agencies to support their activities and help them to advance their legal and policy agendas. In doing so, the Attorney General abides by the duty to keep client communications confidential. The fact that the Attorney General acts as the mayor's and the government's attorney with respect to many critical matters, and will continue to do so, is not inconsistent with the elected Attorney General's role in taking additional action to represent the public and advance the public interest. In fact, the public interest requires an independent Attorney General to work collaboratively with the mayor with respect to matters important to district residents and to provide the best possible advice to the district with respect to its legal affairs. The only reason to enact a provision that limits the Attorney General's authority to act to legal matters in which the Attorney General represents the mayor or the government would be to place the Attorney General under the mayor's control and curtail the Attorney General's independence. In addition to placing the Attorney General under the control of the mayor with respect to the conduct of legal business, the subtitle would permit the mayor to affirmatively assign to the MOLC core legal functions historically performed by the Attorney General and thus eliminate the check and balance that the referendum and 2013 law require. Section 1043A1B of the subtitle would make the MOLC responsible for providing legal sufficiency reviews of legislation, regulations, and contracts at the request of the mayor, provided the Attorney General may also provide such reviews at the request of the mayor. Chairman McDuffie, as you made very clear in your questioning, the language that would allow the MOLC to provide legal sufficiency reviews of legislation, regulations, and contracts is new, it is different, it's dramatic. It certainly was not contained anywhere in the language related to the 2013 legislation. Under Reorganization Order Number 50 in the existing version of Section 101 of the Referendum Act, the Attorney General's core functions in conducting the district's law business have included the review and certification of proposed legislation, rulemakings, and contracts for legal sufficiency. This function has required the Attorney General to provide the executive branch with an independent assessment of the legality of some of the district's most important legal actions. In doing so, the Attorney General has been able to prevent the district from taking action that has had the potential for producing litigation resulting in significant monetary awards against the district. The Attorney General has also provided objective assistance to district agencies in effectively and defensively achieving their legal and policy objectives. I want to make one point concerning Mr. Cook's testimony. Mr. Cook was very right when he talked about legal advice and legal sufficiency and contract deals being iterative. These deals are fluid. Decisions literally are made not necessarily on the fly, but certainly in the full dynamic of deals. And so the deal lawyers are not only advising on law, but right there at the moment when conversations are occurring with a private developer counsel or other counsel making judgments as to whether the provisions or terms contemplated comport with DC law. It's very, very important that the lawyers play the dual role of advising on law and advising on legal sufficiency. The reason is because, of course, Mayor Bowser absolutely is a person of integrity and wants to get it right. The reason why the lawyers are engaged in these activities is because they too want to get it right. It is in fact the lawyers at the Office of Attorney General who will be called upon to defend the city if a deal goes bad. That's why that iterative process of advice and legal sufficiency is so critically important on what are the most important and largest deals that this city does. That's where the rubber hits the road. That's where the money is. That's where the problems occur. That's where the potential for wrongdoing in government occurs. And that is, in fact, what the people wanted this council to do when it approved of an elected attorney general. That is, to have a critical check and balance that wouldn't be a hindrance to a business deal, or wouldn't be a hindrance or an interference to a matter of policy, but instead serve as an important check and balance to ensure that the policy being pursued or the deal being pursued are consistent with DC law. Nothing more and nothing less. By giving the mayor, I didn't see my mother here. By giving the mayor the authority to decide whether significant legal actions should be reviewed by the MOLC or the Attorney General, the subtitle would eliminate one of the Attorney General's core functions, while expanding that of the Director of the MOLC, an unelected official that's neither vetted nor confirmed by the council, accountable only to and employed at the pleasure of the mayor. It would also give the mayor the ability to decide which legal actions should be subject to the Attorney General's independent review. You mentioned the reality of a deal. Imagine, under the mayor's proposed subtitle, the mayor chooses to get legal review, though not legally authorized, from the MOLC. Get that legal review, doesn't seek it from the Office of Attorney General, deal goes forward, Office of Attorney General reviews the terms, later comes and issues an opinion saying, boy, some of those terms violate DC law. Can you imagine the lack of confidence and faith in conducting business in the District of Columbia that businesses will have, knowing that a deal with the mayor's office that doesn't allow for an independent legal sufficiency review from the Attorney General's office could be unwound later? Very real possibility. And the people acted not hypothetically. They acted because of concerns regarding Banneker Ventures, other deals, and they want the Attorney General's legal sufficiency opinion in deals going forward. By giving the MOLC the ability to perform these reviews in lieu of the Attorney General, the subtitle would allow the mayor to decide on a case-by-case basis whether or not to allow independent review, or whether to advise the Attorney General of these and other legal matters in the first place. Legal sufficiency certifications of the Attorney General constitute more than mere legal advice to the executive. They are expressions of legal approval by an independent public official, which are relied upon by the council, the public, and private parties. Checks and balances are a cornerstone of mature democracies. Checks and balances protect the public from excesses of one branch over another. Businesses rely on checks and balances to ensure that contracts that the city enters into are valid and defensible in court. Finally, the subtitle would expand the role of the MOLC to supervising the legal work of subordinate agency counsel. That's in their section 1043A1A of the subtitle. This expansion of the MOLC's role, in combination with other provisions of the subtitle, encroaches upon the Attorney General's role to be the chief legal officer for the district and all of its residents. Our neighbor states, Maryland and Virginia, and I really think this is important because we are not writing on a blank slate here in the District of Columbia. We have models of other states and what they do with respect to separation of powers and checks and balances. Other states that attract business in a way that is greater than that of DC. Other states that are recognized for having business practices that are frankly more accountable, more transparent. Other states that have ratings where businesses rate them as good places to do business. Again, we're not writing on a blank slate. Our neighbor states, Maryland and Virginia, those are our biggest competitors for business. Those states have elected attorney general who are charged with representing the state and the public interests. Those states have functioning checks and balances that the public and business rely upon to ensure lawful and proper functioning of government. I should note that in Maryland, there is indeed a governor's office of legal counsel, general counsel. They have a grand total of 3 or 4 lawyers. In Virginia, the same, grand total, 3 or 4 lawyers. In both those states, the Office of Attorney General does provide legal certification sufficiency reviews for legislation, regulation, and yes, for business deals. The subtitle, Mr. Chairman, violates the district charter. Fred Cook, said it in a few words. I'm not as glib as he, so I'm going to say it in a little bit longer words. The obvious legal defect in the provisions of Subtitle E described above is that purporting to rely on principles of democracy, the subtitle would override the will of the voters as expressed by their approval of the Charter Amendment of 2010. As noted above, the Charter Amendment added a new section 435 to the Home Rule Act that requires the Attorney General to be elected. The subtitle would not amend this section, but it would eliminate many of the core functions, powers, duties, and other characteristics of the Office of Attorney General that the voters ratified when they chose to make the Attorney General an elected office. As noted above, new Section 435 of the Home Rule Act was part of the Referendum Act, which strengthened and expanded the authority and independence of the Attorney General. The Council approved this entire act after public hearings as part of the normal legislative process. Creating an elected office was one of the means the Council included in the Referendum Act to further support the independence of the office at a time when many observers believed that the position of Attorney General had become less independent and too closely associated with the mayor. According to the Referendum Act's committee report, making the charter change is making the position of Attorney General the strong, independent office that the district requires and deserves. District voters participating in the referendum had to have been aware of the reasons for and effects of the Charter Amendment when they decided to make the Attorney General an elected office. The Referendum Act was included in the Charter Amendment that the voters approved, and the Board of Elections mailed a voter's guide containing the entire Charter Amendment to every household in the district. And as we know as elected official, DC folks open their mail and they read their mail. And when they go to the polls after reading the mail, they know what they're voting for. Any suggestion that DC voters did not know what they were voting for when they voted the referendum for an independent Attorney General and then voted overwhelmingly to elect an independent Attorney General, respectfully disrespects the citizens of the District of Columbia. By approving the Charter
Excuse me
Amendment.
for one moment, Mr. Racine. I've sort of let you all pass for a little while, but you all are interrupting the proceedings of this committee, and I would ask that you refrain from clapping or any other forms of demonstrations, or I'll have to ask you to be removed. So thank you for your consideration. Please, Ms. Racine.
Thank you. By approving the Charter Amendment, the voters did by approving the Charter Amendment, the voters did nothing less than incorporate the Referendum Act's vision and requirements for an independent attorney general into the district charter. Courts may consider the intent of both the council and the electorate when interpreting a charter amendment enacted by a referendum. That's a quote from a holding in the case that Paul Zuckerberg brought, that the DC Court of Appeals ruled that the election must go forward. The courts, I should tell you, are absolutely clear on issues regarding the Independent Attorney General Act. The court well understands that the people wanted this. The court well understands that the people's vision for that office is independent, and check and balance should not be frustrated by any proposed bill or even council action. And that, in short, was what that Zuckerberg decision was all about. In addition, I'll pause for a moment. If I can direct our attention just briefly to the real estate lawyers who currently work in the Office of Attorney General, who do the biggest deals that this city has. In addition, as you know, efforts are underway by the Executive Office of the Mayor to unilaterally encroach on the Attorney General's legal responsibility to conduct all the law business in the district and to provide independent review of major commercial transactions. In March, Mr. Toohey referred to this, the Deputy Mayor for Planning and Economic Development, Mr. Kenner, communicated to me the administration's desire to move the reporting lines and duties of the 4 real estate attorneys who are currently under the supervision of the Office of Attorney General's Commercial Division, making them part of a new General Counsel's office based in Demphead. The deputy of OAG's Commercial Division and section chief of OAG's Real Estate Division would also go, according to the mayor's unilateral action, to Demphead in order to supervise the work of the 4 OAG lawyers. Under this plan, these 6 outstanding public servants who currently work on major real estate deals for the district and report through OAG's Commercial Division to the Attorney General would all be moved to the newly created positions within Demphead, outside of the OAG and under the mayor. I should note, to bring you current, and I believe I may have provided you with this last night, Mr. Chairman, the current state of play is that the Executive Office of the Mayor has drafted and issued 2 offer letters to 2 lawyers at the Office of Attorney General, the head of the commercial section and the deputy of the commercial section. They made the offers to those lawyers to come on over and join Demphead. In making that offer, they clearly informed those lawyers that their jobs, the jobs they're doing right now at OAG, were going to go away. That they, those 2 lawyers, could choose to join Demphead or watch their jobs, what they've done at the Office of Attorney General, independently go away. Those 2 lawyers have accepted EOM's offer conditionally, conditioned on whether this council acts to prevent what I believe is action that is completely inconsistent with the charter and the 2013 legislation. I should note, Councilwoman Nadeau quite correctly pointed out the concern of redundancy and added financial waste with all these lawyers getting hired at OAG and the MOLC and elsewhere. Well, you should know that the Executive Office of the Mayor, in extending these offers to my 2 colleagues who I have tremendous respect for, who want nothing more than to be doing their jobs at the Office of Attorney General, well, they received a $24,000 increase and a $15,000 increase, respectively, in order to accept the offers at Demphead. They're honest people. They're going to do their job correctly. I have no doubt about that. And I know that if it's up to them, they will regularly interact with my two colleagues to my right and left on matters of legal sufficiency. I do think that there's a threshold question, respectfully, for this council to assess as to whether in this day, with the laws as they are right now, it's appropriate for the executive office of the mayor to reach in to the office of Attorney General and pull out practicing lawyers to now work in their office to have reporting lines to the mayor. Sorry for the divergence. As you know, in anticipation of the city's first Attorney General election conducted in 2014, the council in 2013 passed the Elected Attorney General Implementation Amendment Act. That act transferred supervision of agency counsel from the Attorney General to subordinate agency heads so that they would be within the mayoral reporting line and not that of the elected Attorney General. These are the general counsel who were at OAG who are now out at the agencies. Attorney General Nathan, the architect of the Elected Attorney General Implementation Amendment Act, specifically distinguished the legal work involved in handling the transaction functions of DEMPHED as complex dispositions of valuable district properties to developers from other agency counsel functions. Whatever the merits of the policy choice in making these changes, getting lawyers out of OAG to go to the agency counsel, this council wisely and intentionally chose not to transfer outside of the OAG the lawyers who handle the critical transactional functions of DEMPHED, such as complex dispositions of valuable district properties to developers. The council distinguished those legal reviews from agency counsel functions. The council wisely and specifically left this OAG function and the personnel who perform it untouched. This choice reflected the council's recognition of the importance of having the attorneys who perform the legal analysis associated with major real estate transactions report to and be supervised by the independent Office of Attorney General. The council specifically left within OAG the legal counsel division and the real estate attorneys in the commercial division, both of which employ experienced lawyers who have traditionally worked in close consultation with other legal experts in the Office of the Attorney General, and the agencies to furnish legal advice to the mayor, deputy mayors, agencies, and the council. Nothing in the text or history of that legislation diminished the Attorney General's pre-existing and essential independent responsibility for, in the words of the charter amendment passed overwhelmingly by the voters in 2010, the charge and conduct of all law business of the district. That was the fundamental premise of the proposal in the bill that was adopted in 2013 concerning the agency counsel transfer. But the continued role of the commercial division and other advice-giving lawyers of the OAG staying as a core part of OAG. At one point during this tortured history of the election of the district's Attorney General, no point was there ever any consideration to having the MOLC to any degree displace the Attorney General in any legal function. As explained above, under the Charter Amendment and the Act, the Attorney General is the Chief Legal Officer and has the exclusive responsibility and obligation to independently perform legal review and legal sufficiency of real estate transaction and deals, regardless of DEMPHED's decision to have legal staff. It does not alter OAG's central legal obligation to provide, to conduct the law business of this city. In order for real estate and land deals to proceed, the executive and OAG must work cooperatively, as we do, with all other legal matters on a daily basis to protect and advance the interests of the district and its residents. The council's decision in 2013 to have the real estate lawyers remain at OAG and for OAG to continue its legal sufficiency reviews because checks and balances of the legal sufficiency of deals that the city enters into is a hallmark of a mature democracy and good government. Good enough for Maryland, good enough for Virginia, good enough for the District of Columbia. The business community relies on this check and balance to have confidence in conducting business in the district. The public interest relies on this check and balance to have confidence that the business deals are consistent with DC law. I will stop at this point. I'm certainly prepared to talk more about our proposal, which are technical in nature with respect to our legislative suggestions, with 2 or 3 more substantive addendum corrections or proposals that would protect DC in various areas in the law. I should have made clear that my colleagues to my left and right, Lori Ainsworth is in the Legal Counsel Division, and of course Janet Robbins is the Deputy of Legal Counsel Division. When you want to talk about legal sufficiency, integrity in the law, and courage in the law, you really want to talk about the work that Legal Counsel Division does and these 2 extraordinary lawyers. And please, I urge you to feel free to ask them any question you might have.
I want to thank you, Mr. Attorney General, for your testimony. I do want to apologize in advance. I had a lot of 4 hours for the hearing. We've already gone over that, due in large part to my extensive questioning. So I may have to adjourn this and reconvene it on April 29th, but I'm going to start to get through it. I've got a pre-existing commitment that is going to require me to leave shortly. But I want to start questions, and we'll more than likely have to finish up later, but in fact, I'm going to start with a 10-minute round for my colleague, Brianne Nadeau, Ward 1, just in case we have to leave early. I'd rather cut my own time than cut her time. So, Ms. Nadeau.
That's very kind of you. Director Nesbitt is also waiting upstairs, so I appreciate that very much. I want to applaud you, Mr. Attorney General, on your prioritization of consumer protection and housing issues. I think it's very clear from your proposal that those are very important issues to you, and I know they're very important issues to our constituents and to many of our colleagues here on the council. I wanted to dig in a little bit on the idea put forth here about a percentage of returns, so to speak, going directly back into the OAG fund to create this consumer protection fund. Merely because for me it raises some flags in really a shift from allowing the Office of the Attorney General to operate more like a corporate law firm with a sense that there's an entitlement to merit pay for doing work rather than what I would see as normal government operations and the need to create a balanced budget based on policy priorities. And I will say that a very clear example of the need to have all settlement funds go directly back into the general operating fund is very clear from this fiscal year, where we had a budget gap. And that money became very important to ensuring we didn't have to make cuts to programs like our housing programs, like our healthcare programs. So I wanted to see if you could speak to that a little bit. That is a big concern for me as a member of the body that is responsible for allocating these funds.
Sure. It's absolutely a fair concern, and I note presence of Mr. Rod Woodson here from the firm of Holland Knight, and I know they represent many clients. They've expressed a similar good faith-based concerns about the Consumer Protection Fund. Let me demystify a few things. First, we formerly had at the OAG a Consumer Protection Fund, and for reasons that frankly no one really knows, that Consumer Protection Fund was eliminated. And this was, if I'm not mistaken, back when Peter Nichols was the AG, or he was the general counsel, and I believe it was that Linda Singer was the AG. So this is, we're not breaking new ground even in the District of Columbia. That's first. Second, we're not breaking new ground certainly in the states. Dozens of states have consumer protection and antitrust funds, and the principle is really, really clear and simple. And that is that because of the wrongdoing that absolutely occurs with bad business practices, the citizens of the District of Columbia are harmed. We therefore should seek redress for those harms and injuries. If OAG recovers funds, no doubt about it, properly those funds should go back to the general fund. What the consumer protection funds in so many states recognize, though, is that reliable investment in consumer protection enforcement requires some funding that is not at the annual whim of the council. And so what I proposed, because we're starting a new Office of Independent Attorney General, and you're right, the consumers and the citizens here want us to focus on consumer protection. What I propose is that we not come to you this year nor even next year and ask you to expand our budget, but instead allow us to capture a percentage of recoveries, not all, a percentage of recoveries that we obtain through affirmative litigation. I think that is consistent with the practices of many, many states. I think there are ways to have good checks and balances to ensure that our office is not running around acting like a plaintiff's law firm, only focused on money and not focused on the public interest. I would propose that we would have regular reporting and oversight. I would propose an advisory board of which the council chair and others in the business community would serve to ensure that the actions of the Office of Attorney General in pursuing damages from wrongdoers is not simply motivated by a desire to feather the nest of the office. So I think your concerns are valid. I believe we can work through those concerns just as 2 dozen states have.
And can you help me with the history here of whether the prior fund was also a stream that came from the percentage of settlements, or if it was merely the whim of the legislative body?
You know, I got to tell you, it's kind of like that MOU that folks referenced earlier with the DEMPED and the EOM. Just can't find the document. I don't know what the history is there.
Mm-hmm.
I will go back and redouble my efforts to inform you of what the history was, because it certainly should inform whatever we do going forward.
Thanks for that. You also spent some time talking about how you'll prioritize affordable housing production, and that is laudable. I wanted to ask specifically about your intent to fully enforce the Tenant Opportunity to Purchase Act. Now, as you know, the way that TOPA works is that tenants will receive notice of intent to sell the property. Tenants will then have the opportunity to form a tenants association. Tenants can then assign their rights to a new owner to develop affordable housing or co-op or become owners in a condo. So where exactly in that process do you see the Attorney General's role?
Sure. And I know that you have been, very, very interested in those issues, clearly looking out for the tenants to make sure they have an opportunity to stay in their homes. What we have found in the entire area of affordable housing is that your average person who lives in DC is confused by the complex, myriad, overlapping, redundant, even conflicting regulations out there. What I would propose to do with additional lawyers and staff, not all lawyers, focused on affordable housing, is first, draft up and published in lay person's friendly language the guide on what affordable housing rules and regulations are that exist in the District of Columbia. It's really important for the citizens to have right at their disposal in one document, a document that plainly lets them understand whether they qualify for a given subsidy or what steps do they have to take to qualify for those subsidies. Additional work that our lawyers and staff would do in this area, I think it's really important for us to go out, as one of the public witnesses testified earlier, and engage the public and talk about exactly what the laws are so that people can be informed on the law such that they might better seek to enforce the law. And in that regard, candidly, the Office of Attorney General has about a half of lawyer dedicated to those efforts now. I should tell you that what we're doing, even though we don't have the FTE dedicated to the lawyer, to that area now, we're out there every day with Peter Edelman and Jim Sandman from Legal Access, encouraging law firms to take on affordable housing cases on a pro bono basis. But what we would do is take on more of those cases ourselves. Fundamentally identify the laws and enforce the laws to the benefit of the tenants. That's what we would do.
Mr. Attorney General, that is laudable, and I cannot disagree with the need for many of the things you just described, but you've fully illustrated my concern about duplicating efforts in that the bulk of what you've just laid out is very squarely within the duties of the Department of Housing and Community Development. And so I have some concerns around that, and I'd like to just sit with that for a moment because my time is about gone, but it's something that perhaps my colleague will want to get into as well, juvenile justice reform.
May I make a suggestion on that
Yes.
point? I think that as we reflect on DCHD and their enforcement prerogatives, what we might do, and I'd love to meet with you on this, is to bring in the entire community. We can thereby get an understanding of the scope of the problem, who's helping, who's not, where the gap in resources and lawyers are. That way we can put the right lawyers in the right place to help our citizens.
Well, I would love to work with you on that, and I would highly recommend that you take a look at the discussion we had this week in the budget oversight hearing for that department, in which we laid out many of the specific issues that need to be resolved, including with TOPA, that may require legal redress, but I believe largely will be resolved under the purview of the executive and the new director there. So my time is up, and I know that my colleague also needs to recess, so I will leave it. And I hope that when the committee resumes, there can be some discussion about, about juvenile justice and truancy and how the items that you've proposed are in coordination and are not, in fact, duplicating other programs that we've all pledged to support. I thank you, Mr. Chairman, I thank you for the time and for allowing me to go first.
Sure, thank you, Councilmember. I apologize to folks who are here that I'm going to have to adjourn this hearing, but I want to ask one thing that is relevant to this discussion. And I want to point out that obviously we're going to tackle this issue on April 29th when we have the budget oversight hearing for the Office of the Attorney General. But I want to ask first a question around legal sufficiency. And the Attorney General currently is required to furnish opinions in writing to the mayor and the council whenever requested to do so, and that's law. There's no mention in the existing law of a duty or even a procedure by which the OAG would review the legal sufficiency of legislation, contracts, or other transactions, yet this has been the practice in the District of Columbia. Where do you look to support the OAG's authority to provide legal sufficiency?
Sure, and I certainly will defer to my colleagues here. I think Mr. Cook had it exactly right. When you're talking about the law business of the District of Columbia, you clearly are talking about ensuring that legislation, regulation, and deals are made in conformance with the District of Columbia law. That is the source of our authority as I see it. I would add, again, that look at it on the backside. If we're not involved at the beginning of this process, what happens when a deal goes bad? When a deal goes bad, you're going to call your lawyer. The lawyer's going to come in, and the lawyer's going to make an assessment as to whether the city can defend the action. It makes common sense that law business would require the Attorney General to be involved in the decision of legal sufficiency in the first instance, so as to ensure and support a mayor deal that goes through. We in the other states, every state that has an elected attorney general does legal sufficiency. We are the insurance policy for the executive's actions. For the life of me, I don't know why they would ever want to fly without insurance.
Well, let me just ask this though. So just so that I'm clear, and in case you want to defer to one of your colleagues, is there anywhere in the law that the Office of the Attorney General can look to derive that authority to provide legal sufficiency? And then also, how do you define the work that you all do in terms of providing legal sufficiency certification?
Thank you. I think that the term legal sufficiency is not in the law specifically, but the law itself requires that the Attorney General is in charge of he has charge and conduct of all the law of business of the state, of the district. And that provides the basis for the Attorney General to have an independent look at every significant legal action in the district. And what we do in the Legal Counsel Division, we provide legal advice, first of all, to the Office of the Attorney General, the Mayor's Office, and we have been working with the Mayor's Office and the agencies to continue to provide that under Mayor Bowser. But we provide legal advice by looking at our legal sufficiency review specifically. We look at whether something that's given to us, a law or a regulation, is consistent with the Constitution, with federal law, with district law, that the other statutes in the district, that is consistent with those, that they work together, that there's, we'll look at, we have people who are expert in appropriations and budget, like Lori sitting to my left. We have people look at that. We work with, if needed be, we work with lawyers in Maine OAG who are litigators to help us understand potential litigation risks. And we provide a document that doesn't, a memorandum, that doesn't focus at all on policy. It only looks at legal concerns that might be raised. It explains legal risks. And we try to work with the executive where it's necessary, and oftentimes it's not, to make sure that they understand what the legal risks are. And generally, they want to resolve them. So that when we've completed legal sufficiency review and worked with the executive or an agency, there's a document that they can feel comfortable has had an independent legal review and can go on to counsel or, and everything, by the way, all of our legal sufficiency reviews, when we give them at a stage before they're introduced to counsel, are covered by the attorney-client privilege. We view that. And so our memos are not handed out to the press or to the council. And if they were, there would be a concern that if the mayor chose not to go with our proposal, that, and sometimes the mayor does not, that we'd give a roadmap to litigators who want to fight against the district.
Are those the documents that you all, and I'm simply not going to be able to get into this to the degree I want to right now, and I apologize for that if folks are at home watching or seated here. Are those documents that you provide, those legal sufficiencies documents, in your opinion, is that document privileged? Is that a document that's being provided from a lawyer to the client?
When the mayor, because there's a regular practice when the mayor sends us legislation or rules to review, and we review and we prepare a memorandum, we view that memorandum as privileged and confidential.
Okay. Again, I apologize.
Councilman McDuffie, can I just make one point that I think really folks were focusing on earlier, and it relates to legal sufficiency and it relates to our limited review, because there were suggestions about our reviewing policy and not liking a business deal just because we don't like it. You should know in real time that we, of course, at the Office of Attorney General, we were asked to review the controversial contract that the council passed on just last week, the Horizon deal, okay? Folks came to see us at the Office of Attorney General, wanted to lobby and otherwise, express their views. All we did was focused on one thing. Are the contractual terms consistent with DC law? We didn't get into policy. We didn't get into whether a party is a bad business partner or not. We decided it right down the middle on the law. And that's what legal sufficiency is.
Okay, but let me just say this, and I had more of an opportunity to really ask questions, get answers from the mayor's Office of Legal Counsel and the representatives from the executive. I intend to do that with you during the budget oversight hearing. I will say, although there were a number of witnesses who testified essentially in favor of preserving the independence of the Office of the Attorney General, there's a real concern that I think that the executive raised with overreach and whether or not what the overwhelming majority of district voters voted for should be placed in context with the responsibility and the authority vested in the mayor, who's the chief executive of the government. And that is something that we really need to flesh out. It is my hope that this is a conversation that can happen with you as Attorney General and the mayor and her representatives to try to figure out perhaps how to preserve the status quo. What I heard today was there were less areas of difference or dispute, I think, than I might have anticipated coming into this hearing. And I think that there's a real possibility to reach an agreement or some middle ground as to what the role and responsibilities of the mayor's Office of Legal Counsel is and where you preserve the roles and the duties that had traditionally been performed by the Office of the Attorney General without necessarily having to legislate one or the other. I do have concerns about the bill that you sent down to the council that would create a number of new enhance the authority of the Attorney General. And I won't get into it today. I will get into it over budget, but there are a number of things that will give you exclusive power to issue formal legal opinions binding on all offices, agencies, departments, and instrumentalities of the district government. And how broad and how all-encompassing is that authority that you're asking for? There's another line where you ask for power and duty to provide formal and legal advice in writing to the mayor, council, and all offices, and it says including all matters that could reasonably be expected to lead to litigation. I'm sort of wondering what matters might not lead to litigation. In other words, how broad is this authority that you're asking for? And where do we draw the line with the separation of powers and the checks and balances that I think people voted for, but also granting and respecting the role and responsibility of the executive and the council to be able to carry out their missions and mandates as well. The exclusive authority to settle all claims and suits involving the district, the power and duty to review in advance. And I think the mayor's folks raised this legitimately, this request that you have that you'd like to have the power and duty to review in advance and to certify, if appropriate, the legal sufficiency of all actions of legal consequence to be taken by the district government as determined by the Attorney General. And you list a number of things, including proposed legislation. That is the kind of authority that I think, actually I don't think, I think the representatives of the mayor actually testified to that prompted them to perhaps include this subtitle in the BSA. It was the concern of overreach on the part of your office. So I would like to see that dialogue, and I'll give credit to the mayor's representatives who testified. They urged us being the council, to table the proposals and to instead work with the executive and the Office of the Attorney General to begin a dialogue about the future legal services in the District of Columbia. I would encourage your office and the mayor's office to perhaps have that dialogue, and I'll be a part of that dialogue if you need the council to play a role in that. I'm more than happy to do it. I've spent the better part of the last few weeks digging deeply into what's being proposed by your office as well as what's being proposed by the mayor's office. And I want to just continue to urge congeniality and respect for both of the offices. And for the public to recognize that I don't think this is as bad as it's been made to seem in the media. I think this is a legitimate concern by the executive about where her role starts and stops and where the responsibilities and roles of this new office of the Attorney General starts and stops as well. And I think that's the conversation that we need to have and a dialogue that needs to continue. And I'll be more than happy to do that when we convene the budget oversight hearing later on this month. So I do appreciate you being here to testify, Mr. Attorney General. I do appreciate the representatives of the mayor's office, Beverly Perry, as well as Mark Tui and Ron Ross, who testified earlier. I am going to adjourn this roundtable on the proposals relating to the powers of the Office of the Attorney General and the Mayor's Office of Legal Counsel today, but I will cover these issues that we weren't able to get to on April 29th, April 29th, when we had the budget oversight hearing for the Office of the Attorney General. There being no further business at this time before this Committee on Judiciary, the time being 2:45 p.m., we're going to adjourn this roundtable. Thank you.
Thank you very much.